I am just getting everything powered up in the courtroom, and I've been asked to start with AC/DC, so we'll do that.
Thank you.
You're welcome.
And good morning, Judge. I'm here for Angelo Williams.
Okay.
Good morning, Judge. I'm here for a plea for Mr. Shilenge.
Okay.
Shilenge.
Say that again.
I'm here on a plea for Kimberly Shilenge.
Okay.
Your Honor, I don't know if the court can accommodate me. I have a hearing that is going to start at 9:30 in Cherokee County. I'm actually in court in the conference room trying to do this plea so I can run back to them.
Okay, we'll see what we can do. Let's get everything fired up first.
Thank you, Judge.
Okay. Came in.
I don't know if anybody can hear me. I'm going to excuse myself really quick and go use the restroom. I'll be right back.
Okay.
Thank you.
Ms. Smith, good morning. Are you ready to do the plea on Ms. Shilenge if we did that first?
Good morning, Judge. Yes, I'm ready for that plea.
Okay. And Attorney Bucola, you're ready?
Yes, this is Attorney Tiku, Your Honor. I'm ready.
Oh, we got Mr. Tiku here. Excellent. Okay.
Thank you, Judge.
Let me get everyone on the screen here. We need Mr. Tiku. And your client is where?
I think she's the one that just excused herself to go to the restroom. If I'm
Didn't realize that. So let's add her to the spotlight. She's back. Ms. Shilenge, can you hear us?
Yes, I can hear. Can you hear me?
Yes, ma'am. Are you ready for us to go forward?
Yes, I am.
Great. Then last thing is I need to confirm that Ms. Martin can hear us. Good morning, Ms. Martin.
Good morning. I didn't want to interfere, but I'm here.
Excellent. No, you're never interfering. In fact, you should pipe up if it's hard to hear things. Everything will be virtual today, including you, unless someone decides to walk into the courtroom where I'm sitting. We're starting out by taking a plea from the trial calendar from yesterday. So I don't know that you've got that in front of you, but I'll give you the style of the case in just a moment. And I'll always let you know when we need to be on the record. Some of the cases we handle today, we don't need to make a record of. So I'll let you know when we need to go live, okay?
Oh, that is excellent. Thank you so much.
Hey, no problem. Ms. Wood, if you want to give me the Well, I guess I could just put AC/DC into the breakout room and then people could speak how they're going to speak. Does that work for you, Ms. Wood?
That would be perfect, Judge. I think I have pleas from AC/DC, so if I could just do that while this plea is happening, then that might expedite our calendar.
So what I'll do is put AC/DC and you into a breakout room and then you guys can see what happens.
Thank you, Judge.
All right.
Judge, good morning. At some point, I would need a breakout room to see Mr. Sorrells whenever they're on.
Okay, we'll get to that. That's going to be juggling more balls than I can juggle and something will hit the
understand.
ground and break. So,
Okay.
but we'll certainly do that. But let me get Ms. Wood and AC/DC into a breakout room and then we will do Ms. Shalenge's please.
All right.
So AC/DC and Lacey Wood. Hope that works.
Thank
There you
you.
go. All right, we'll see what happens there. But let's pivot to Ms. Shalenge. That is position 8 on our trial calendar. It's 26 SC 000-480. Ms. Shalenge is represented by Mr. Tiku, who is appearing from another jurisdiction. Ms. Smith is the prosecutor. And then I believe, if memory serves me correctly, there's a second case that's a misdemeanor, and I'll need that case number, so we're making a good record for that as well. Ms. Smith, do you have that case number?
I do, Judge. It is 25 CR 003136K.
K, as in special K.
Yes, correct.
Okay, all right. So Ms. Shalenge, I'm Judge McBurney. We've met before, but what we're going to do now is take a plea in your 2 cases. One involves felonies, that's the case with me, and the other is a misdemeanor case with Judge Wolf, but he and the prosecutors in that courtroom have agreed to have it handled here. In a moment, Ms. Smith is going to put you under oath, and then she will ask you questions about your rights, about the facts of the case, et cetera. You need to answer her truthfully and completely. You also need to let me know if at any point you cannot hear us because of technical difficulties, or if someone says something that confuses you or doesn't make sense. Will you do that?
Yes, sir.
Okay. You have the right to be here in court, but you are choosing to appear, I'm assuming you're at home, but you're somewhere that's not in court. Are you waiving your right to be here in court?
I fully do not understand that question, but I am agreeing that I am online according to my lawyer.
Okay, and you're agreeing to appear are you at home?
Yes.
Okay, you're agreeing to appear from home and you're not upset or unhappy that you're not here in the courtroom. Is that correct?
No, I'm not upset.
Okay. You also have the right to have Mr. Tiku right next to you, so you could turn your head and say, hey, what's going on? But you and he, Mr. Tiku, are agreeing that you're going to be in 2 different places. I can get you into a private breakout room, or you could drop off this call and talk to each other on the phone if you need to have a private conversation. But for now, you and Mr. Tiku are in different places while we do this plea. Are you upset or unhappy about that?
I am not upset about it. I actually agree for Mr. Tiku to answer for me as my lawyer.
Okay. And he will do that in some situations, but you will need to answer some of these questions as well. They'll be directed to you and not to Mr. Tiku, okay?
All right.
All right, Ms. Smith.
Thank you. Mr. Linjay, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Kimberly Shalenge.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
No.
How old are you and how far have you gone in school?
37. I graduated in Roswell High School in 2007.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
I don't know how to answer that question. With my attorney, we are part-time. So if anything further was to be done or said, I would take it up with my attorney.
So I'm going to ask it. I think I understand that, Ms. Shalenge, but I'm going to ask it in a different way. I know that you and Mr. Tiku have had an opportunity to discuss your cases. The question right now is whether you need more time right now to ask him questions, or if instead you were saying, hey, something may come up that I need to talk to him about. But as of right now, right this moment, I'm good and we can go forward.
I'm good with Mr. Tiku.
Okay, we'll go forward.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
I do.
Ms. Selenje, do you remember being arrested on these charges?
I remember turning myself in.
Okay. The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
I am not.
I'm not.
Do you understand that this is a negotiated plea where the state and defense have agreed to a sentence of 5 years to serve 2 months with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes. I think. Yes.
Okay.
Don't know, honestly. I don't know how to answer that question, but I would say.
Well, when Ms. Smith says, "Are you aware?" Another way she might be putting it is, "Do you understand that?" And what she said is correct. I have the ability and authority to sentence you in the manner that I think is reasonable and appropriate in this case. Your lawyer and Ms. Smith have agreed to a particular sentence, 5 years to serve 2 months with a balance on probation. They both think that's a reasonable sentence. I may agree with them, but if I don't agree with them, I can give you a different sentence up to the maximum in your case. That's what Ms. Smith was sharing with you.
Yes, I agree with Mr. Tiku. I do.
Okay, but you also understand that if I think that your lawyer got it wrong and a different sentence is appropriate, I can impose a different sentence. You understand that?
Yes.
Okay.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, that your probation or parole may be revoked based on you entering this guilty plea today?
Yes.
Are you a United States citizen?
No.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction would at a trial? And this is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty? I'm sorry.
Did you have a question, Ms. Shalenge?
May I?
You may.
My residency. I didn't understand the last question she asked. Does that mean by me accepting this, my residency will be canceled?
So the best answer to that is Mr. Tiku doesn't know for sure, and certainly Ms. Smith and I don't know for sure. And so it's appropriate to alert you to the possibility that your guilty plea could result in your removal from the United States. Ms. Smith is not an immigration law expert. I certainly am not. Mr. Tiku may have experience in that field, but he wouldn't be the one who would decide whether there is a residency impact of these two pleas. And so Ms. Smith is doing the right thing here, which is putting you on notice that immigration authorities could decide after you enter your pleas in both these cases that that's going to have a negative effect on your ability to stay here in the United States. It's not a necessary, it may not happen, I don't know, but it could, and we want to make sure you're going into this with your eyes wide open, understanding that there could be consequences.
Okay.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Attorney Tiku, is Ms. Celine J taking this plea under first offender?
That's correct.
Ms. Celine J, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes. According to my lawyer, yes.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney explained what the First Offender Act is to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes.
Do you understand that a federal government considers a first offender plea a conviction for purposes of deportation and could still affect your ability to remain?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I do.
Ms. Celine J, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 000480, how do you plead to count 1, aggravated assault, and count 2, aggravated assault? Sorry, I couldn't hear you.
So, Ms. Shalenge, this is when you are going to tell me either you're pleading guilty, you want to resolve the case, or you're pleading not guilty, in which case we need to take you to trial on Monday in the aggravated assault case. So I'm assuming this is what you and Mr. Tiku had discussed.
Yes, I will take the plea Mr. Tiku and I discussed.
Okay, so then you are pleading guilty to the aggravated assault charges. Is that correct?
Yes, whatever my lawyer presented, I am going with it.
Okay.
As to the other indictment, 25 CR 003136K, how do you plead to count 1, simple battery, and count 2, simple battery? Guilty or not guilty?
I will let my lawyer speak for me.
Well, he can speak for a moment, but then you're going to need to answer because it's a question of whether you are admitting responsibility for the misdemeanor case.
I do. I admit everything that I spoke with my lawyer.
Okay. Mr. Tiku, can you help us out with that?
Yes, Your Honor. Ms. Selenji, what we talked about is the fact that you had two cases, a state case and a superior court case, and you're going to plead guilty to both of those cases. And based on that, we consolidated the cases, so it's going to be one sentence. So it is my understanding with the discussion with you that you understood that.
Yes,
You're going to
yeah,
plead
we
guilty.
had spoken about that before. Yes.
Okay. So regarding 25 CR 003136K, how do you please to count one simple battery and count two simple battery? Guilty or not guilty? Ms. Linda.
Oh, well, I'm going to according the agreement we had with my lawyer. Yes,
Okay, so Mr. Tiku explained to me and to Ms. Smith that you were pleading guilty in both cases. Are you pleading guilty then in the misdemeanor case as well?
yes.
Okay.
With everything my lawyer said, I agree.
Okay.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes,
Do you also understand that that process has to be completed within 30 days from today?
yes,
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes,
Okay. Thank you, Mr. Lynn J. Your Honor, in the indictment ending in 0480, if this case were to proceed to trial, the facts would show that on January 9th, 2026, officers of the of the Roswell Police Department responded to a domestic call at 140 Worthen Hills. That's in Atlanta, Georgia, also Fulton. I'm sorry, that's in Fulton County. When the officers got there, they made contact with the reporting party in this case. Their initials are NS. They are a minor, and to my understanding, they are the nephew of the defendant in this case. When the officers got there, the reporting party told the officers that they had ongoing issues with Miss Kimberly Solange, the defendant in this case, including their grandmother, Nancy Solange, who isn't a victim in this case, but just reported in the police report. The reporting party told the officers that on the day, January 9th, 2026, the defendant got into a verbal altercation with her sister and also with other parties of the family, at which Miss Solange pulled out a knife from the kitchen and attempted to strike her sister with it, the victim in this case. And also after that, on the same day, she had an airsoft gun. She went into her nephew's room and pointed it at his bed. It was an airsoft gun, however, that's what she pointed at her nephew, which is why she has both of those ag assault charges that we have in front of us. When the officers got a chance to speak with Sheila, that's the victim in this case, and also Mr. Lynn J's sister, she said that she's experienced similar threats from the defendant in this case in the past, and they've had other domestic violence incidents. However, she did say that she did not, the defendant in this case did not make contact with her when it came to the knife. However, she did have the knife with the intention of pointing it at her or intimidating her. At this time, the defendant was taken into custody for the charges we have in front of us. For the indictment ending in 136K, this was on December 2nd, 2023. Facts would show that the officers of Roswell Police Department responded to that same incident location. So 140 um, Worthington Hills in Fulton County. When the officers got there, they made contact with the defendant in this case who was sitting outside. They asked the defendant what happened, and she told them that her and her sisters were having an argument about food. And when they asked specifically what about the food, the defendant stated that her sisters tried to take all of her food, and it's been an ongoing issue, so they got into a verbal altercation. The officers then entered the home where they got a chance to speak with Nancy and Sheila and also Beverly, they're all sisters and relatives of the defendant in this case. When they got a chance to speak with the victim, they stated that she got into a verbal altercation with the defendant in this case. At that time, she picked up a banana holder and threw it toward the victims in an attempt to make contact with them. The victims in this case were not harmed. However, that is what occurred as far as the simple battery in this case. I did get a chance to speak with the victim. And I got a chance to speak with the victim in the first case and also the victim in the second case, Miss Sheila. She told me that the ongoing issue she has with her sisters is just a sibling thing that's going on. She does not fear for her life, and she would like her sister to not be incarcerated for the crimes that we have before us. But those are the facts and circumstances for both of those indictments we have in front of us. As far as the negotiated plea between the state and defense, we've agreed to a sentence of 5 years to serve 2 months commuted to time served with the balance probated. Regarding the special conditions of probation, we've agreed for the defendant to complete a family violence intervention program, to have no violent contact with the victims, and to also have a mental health evaluation with treatment if necessary. And that is all from the state, Your Honor.
Okay. Ms. Shalenge, are you still there? We're not seeing you. I think we're seeing the ceiling of your apartment or house.
Hello?
Yes, can you hear us?
What did you say?
I wanted to make sure you were still there. We couldn't see you.
Oh, no, I'm here. I'm sorry. I'm here.
Okay, you ready to keep going?
Yes.
All right. Thank you, Ms. Smith, for all that. It was very thorough. I am going to ask pretrial services to let me know what criminal history, if any, they have on Ms. Shalenge.
Good morning. I show a total of 4 cycles. I do not see any convictions. I do see a cruelty to children in the 3rd degree from 2010. The disposition says record restricted per OCGA. And then she had a cruelty, and nothing further.
Okay, so 4 cycles, no convictions that you can find.
Correct, yes.
All right. Thank you, Ms. Hutcherson. Mr. Tiku.
Yes, Your Honor. Your Honor, I asked that based on the fact that the victim doesn't want to go further with this case, based on the fact that my client doesn't have a conviction, I'm asking the court to accept the plea as negotiated.
All right. And you, Mr. Tiku, have discussed with Ms. Shalenge at least your views on the potential immigration impact of these pleas. I know that's not necessarily your expertise, but you've at least engaged with your client on that?
Yes, Judge.
Okay. Ms. Shalenge, do you have any questions for me or anything you want to add?
No, sir.
Okay. Tell me where you were born.
Kenya,
How long have you been in the United States?
22 years.
Have you been working in the last few years?
Yes.
What kind of work do you do?
My last main important job I had before I turned myself with was with WellStar.
And what did you do for Wellstar?
I was a nursing tech.
Okay. And do you still live with family at the Worthington Hills address?
Unfortunately, after all this happened and I turned myself in, I lost my place. And the only person I know in this country is my mother. And last I was in court, the judge allowed me to go back to 140, where that's where my mother resides.
So you are living with your mother?
Yes.
Okay. You say the only person you know in this country is your mother, but my understanding was you were living with your sisters and a nephew.
They also live with my mother.
Okay. So you are all back together again?
Yes.
Okay. Is that a problem or is that going okay?
I honestly think it's not a good idea for me to be back in this home, but there's nothing else I can do. Like I say, she's the only one I know.
Okay. Well, Ms. Shalenge, I find there's a factual basis for your plea in both cases. You got upset and maybe other people got upset and you took some steps that frightened other people. And you need to be careful about that going forward. I also find that your pleas are voluntary, meaning no one's forcing you to enter this plea, but you've decided to enter your two pleas after speaking with your lawyer and having confidence in his advice. Is that a fair statement?
Yes.
And a knowing plea simply means you've understood the things we talked about after your lawyer helped you understand them, but you feel like you know what's going on right now. Is that a fair statement?
Yes.
Mr. Tiku, do you authorize someone in my office to sign the indictment on the felony case and the accusation in the misdemeanor case for both you and your client?
I do, Judge.
Ms. Smith, can someone sign for you?
Yes, Judge.
All right. Ms. Shalenge, you are asking to be sentenced as a first offender in your felony case, and I will do that. That means that it is not a conviction. It is still something that might cause immigration authorities to take action, but significantly, it's not a conviction, which will help with employment. If you try to get further education, it will not be an obstacle to that. You'll still be under sentence and you'll still need to abide by the conditions of your sentence.
Okay.
That's the upside of first offender. The downside of first offender that I need to make sure you understand is that if you get in trouble while you are on this sentence, and by trouble, I mean you get arrested, not that you get into an argument with someone, but you actually get arrested. Not only would you have new charges, but you would come back into court and the state could argue for, and I could decide to resentence you without a trial up to the maximum in your case. And in your felony case, that would be 40 years. I'm not saying that's what would happen, but I am letting you know that if we are together again in 6 months or a year, because you threw something at a sister or you swung at your nephew, and you got arrested for that, and there's evidence that that happened, then you could lose your first offender status and you might well be resentenced to some time in custody. Do you feel like you understand that consequence?
Yes.
Do you still want to be sentenced as a first offender?
Yes.
Okay, I'll do that. Your sentence as to count 1 in 26 SC 000480 is 5 years to serve 1 month. You actually did less than 2, more than 1. So I'm going to sentence you to 1 month, but you've already served that month with a balance on probation. Same sentence for count 2. They'll run concurrently or at the same time. And 3 special conditions of probation. 1, you're going to have no violent contact with your family members. 2, you will complete a family violence intervention program, and you need to enroll in that program within the first 2 months of probation. You don't have to finish it, but you need to get started within the first 2 months of probation. Also, within the first 2 months of probation, you need to have a mental health evaluation so that a medical professional can recommend if there's any treatment that's appropriate, whether that's medication or therapy or what. And that medical professional may say there's no issue here at all, but that person may say that you would benefit from A or B or C. And those recommendations of the medical professional will become a condition of your probation. Your sentence in 25 CR 003, I need you to remind me, Ms. Smith, how many counts are in that?
2 counts, Judge, of simple battery.
Okay, then this is the banana holder.
Yes, correct.
Simple battery. Okay, Ms. Shalenge, in that case, 25 CR 003 136K, as in Kappa, your sentence for both counts is 1 month to serve. You've already served that month, so that case will be closed out, and you'll be on probation in the felony case. Do you have any questions about anything I've said about what your sentence is?
No, sir.
Mr. Tiku, anything else on behalf of your client?
No, Your Honor.
Ms. Smith, anything else?
Nothing further, thank you.
Ms. Simpson, good morning. Could you chime in and let Mr. Tiku and Ms. Shalenge know what her reporting requirements are?
Good morning. So Ms. Shalenge, is the same address that you're staying at the same address that's in the system for you to receive court notices?
Yes.
Okay, so
140 Worthington Hills, Trace.
It is. I'm looking at it, Ms. Simpson. That is it. So if you go into Odyssey, that's the address.
okay,
Yes.
and that is a Fulton County address?
Yes.
Okay, so your reporting date will be June the 26th at 8 a.m. And you're going to report to the Atlanta Probation Office. That address is 276 Memorial Drive. That's in Atlanta, and the zip code is 30303.
Ms. Shalenge, do you feel like you've got that information? Do you need your lawyer to get it to you? Or I want to make sure you don't want to miss that first meeting, because then they just send me a warrant saying we can't find this person.
I think I got it June 26th, 8 a.m., 276 Memorial Drive, zip code 30303.
That's correct.
Excellent. All right. Thank you, everyone. Ms. Shalenge, Mr. Tiku, you are free to go.
Thank you, Judge. And thank you for accommodating me.
Thank you, Mr. Tiku.
Thank you very much. Thank you. Thank you very much.
All right. Bye-bye.
Thank you, Judge.
So I have been asked, as I mentioned at the start of the call, to do AC/DC first. Ms. Wood, did you have any success with the breakout?
Yes, I had great success, Judge.
Okay, before we dive into that, Ms. Rios, did you have success with your breakout?
No, because booth 4, the sound wasn't working, and he said they told him to move to booth 3.
So I had the right person in the mix with you?
Yes, it was the right person. He could hear me. I just couldn't hear him because it pulled up. It looked. I could see that it was his booth was muted. And
Oh yeah, I can unmute it if he can. Can he go back, or he's in booth 3 now?
I think he moved because he left out. So I think he went to booth 3.
All right, let's see if we can find him so you two can talk while we handle AC/DC. But one more thing before I do that. In court right now is Mr. Willie Taylor. He's position 11 on our Jensen calendar. So we'll handle his arraignment in a minute. I want to knock out the AC/DC situation, but I wanted to let you know Mr. Taylor is here with me.
Okay.
All right.
Mm-hmm.
Do you want him to give you a call and you want to do that first, or?
No, we can do a scheduling order for Mr. Taylor. We've already spoke. He got bailed out by the Juneteenth bail program.
Okay.
And so we could just do a scheduling order. If I could just, I have the number to a family member, but if he has a number, if I could just get that number and he can be on his way, because I should have, because all that we were going to address today was the waiver and then the not a bond hearing anymore since he's out. So we are good.
Okay. Let me call up his case and there he is. So I've got an address on Jonesboro Road in Union City. Is that where you're going to be, Mr. Taylor?
Yes, sir.
5015?
5015 Jonesboro Road, Union City, Georgia.
Yep.
30291.
Great. So we've got the right, I'm sorry.
I told you going to Salvation Army. Can I get in touch with them?
Ms. Rios can help you with that. I'm not sure how to answer that. But if you would write down good phone numbers for you, I'll make sure those get to Ms. Rios and she will talk with you. Sure. So it looks like, Ms. Rios, you did the waiver of arraignment a month ago, back in May. So we'll get a scheduling order going, and then Mr. Taylor may need a little help from you about connecting with the Salvation Army, is what he said.
Yes, Your Honor.
Okay. So, Mr. Taylor, once you leave that info with Deputy Gordon, you're good to go. Ms. Rios will call you when she has the opportunity. She's stuck on this call for a little while.
Yes, sir. Thank you so much.
All right, thanks for being here. Do you want to keep your piece of paper?
Sure, yes, sir.
It's good for you to have that case number.
Thank you, yes.
Trade you. Ms. Rios, when I have a chance, I will send you the phone numbers through chat.
Okay, thank you.
Thank y'all.
You bet. All right, so
This is Attorney Mike Moran. Could I jump in for 2 seconds here, Your Honor?
Yes, sir.
Michael Denizard was on your arraignment calendar, and we have waived formal arraignment, but have a bond motion. He's in custody, and I just wanted to make sure that he was going to be available for our hearing this morning.
He should be. He should be in booth 2 on 4 South. Let's see. South booth 2. Is that your client?
Yes.
All right, he's there. We will get to that. I need to do the city jail cases first, and then we will march through the calendar.
Excellent. Thank you, Your Honor.
You bet. Ms. Rios, is that Mr. Sorrells there on the screen?
Yeah.
All right, I will get him into a breakout room with you and make sure he is unmuted.
Thank you.
Sure. Actually, he is in. Can you go back to booth 1, Mr. Sorrells? It's in the breakout room, and I will unmute it. And then, Ms. Rios, I'm going to get you back into room 2.
Okay.
Make that happen. Ms. Rios, are you able to join room 2?
I was like, it looks like I was moving and then it brought me back. So I'm not sure what happened.
Yeah. I don't know how to make you. Darn. All right. I got to do this all over again. We'll close all the rooms. That wasn't the right move. There.
That was, and then it went back.
Okay. I'm going to see if I can fix it.
Okay.
All right, they should be in there. Okay. We've got AC/DC and Ms. Wood. Tell me what you want to do first. I have 4 names there. We have Leslie Cook, Ms. Prather, Ms. Butts, and Mr. Jones.
Yes, Judge. So Leslie Cook and Miss Prather are mine. Just to give you a little overview, and I guess it would probably make more sense, I think, to start with Mr. Cook. So he has, if I counted correctly, he's got these 3 cases that are on this calendar, and then an additional indicted case, 26 SC 000570.
Okay,
And then position 6, I believe, was actually re-indicted. It's just got the 01 after it.
correct.
Okay. And I think, I'm sorry, I know this is a lot of information. I believe there's an open PI that's showing in Odyssey. I think it was wrapped up into the re-indictment, 25 PI 008512. Miss Smith,
Okay.
please correct me if I'm wrong. We also have a revocation that needs to be wrapped into this plea. And it is a non-negotiated plea, but he understands what's happening. So we are ready to go when the court's ready.
So Mr. Cook wants to plead to, it sounds like it's 4 indictments, and then there's a revocation in the mix as well.
Yes, Judge.
Okay. Ms. Smith, is this something you are prepared to do?
I am, Judge.
Woo, all right. Then let's do it. Mr. Cook, are you ready to go?
I think so.
Well, if you're not, we can handle the other case first.
No, I'm ready.
Okay. Then we will handle things. Let me just get Ms. Smith on the screen as well. There she is. Okay. So it's going to be an interesting one. What is the revocation number?
It is docket 23 SC 190975. And he has 2 years, 5 months, 16 days remaining, Judge.
Okay, thank you. Mr. Cook, we're going to see if we can get through pleas on 4 cases and a revocation on 1 case. The 4 cases to which you would be entering pleas are 26 SC 000570, 26 SC 001 826, 827, and then 828, although 828 is -01. There was a re-indictment of that case. And I think technically Mr. Cook would need to be arraigned on that. Ms. Wood, is he waiving arraignment on that re-indictment?
Yes, Judge.
So we'll go forward with pleas on those 4 cases. We'll get to the revocation at the end. Mr. Cook, you are appearing from the city jail, not here in my courtroom. Are you waiving your right to be here in court?
Yes, sir.
And you also have a right to have Ms. Wood by your side for these proceedings, but she is somewhere else. You're both appearing virtually. You can speak with her privately if you need to. Are you comfortable going forward in this setting?
I'm comfortable going forward.
Then we'll do that. Ms. Smith is going to put you under oath, ask you questions about your rights. She'll cover some of the basic facts about the 4 cases, and we will go from there. Ms. Smith, when you're ready.
Yes, Judge, thank you. Mr. Cook, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I promise.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Leslie Robert Cook.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you would normally take that you haven't been given today?
Yes, ma'am.
What do you take medication for, Mr. Cook?
Depression.
Okay, and you did not get that today?
No, sir.
When do you normally take it?
10:30, 11 o'clock, but I'm good.
Okay, 10:30 or 11 o'clock in the morning?
Yes, sir.
Okay, but you feel like you understand what's going on here?
Yes, sir, I do.
Okay, then we'll keep going.
All right. Mr. Cook, how old are you and how far have you gone in school?
63. I have a GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these 4 indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Very much.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Cook, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for each charge in each indictment?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, and the right to obtain employment, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Cook, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 26 SC 001826, how do you plead to count 1, burglary in the second degree, count 2, criminal damage to property in the second degree, count 3, theft by taking, count 4, burglary in the second degree, and count 5, criminal damage to property in the second degree?
Guilty.
As to indictment number 26 SC 001828-01, how do you plead to count 1, burglary in the second degree, count 2, criminal damage to property in the second degree, count 3, theft by shoplifting, count 4, burglary in the second degree, count 5, criminal damage to property in the second degree, and count 6, theft by shoplifting?
Guilty.
As to indictment number 26 SC 001827, how do you plead to count one, criminal damage to property in the second degree?
Guilty.
And as to indictment number 26 SC 000570, how do you plead to burglary in the second degree and criminal damage to property in the second degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, Mr. Cook. Judge, starting with indictment ending in 1826, if this case were to proceed to trial, the facts would show that on July 12th, 2025, the defendant entered Geno's Classic Barbers, or it says Barbers in the warrant, but I think it's Burgers, located at 1170 Crescent Avenue Northeast. That's in Atlanta, Georgia, also in Fulton County. There was surveillance on the property that showed that Mr. Cook used a rock to break the door of this establishment. He then went inside and discovered $278 in the cash register that he stole before fleeing on foot. That is for the first 3 charges. For those last 3, the burglary and the second degree and criminal damage, happened at the same location. It just happened on July 15th, 2025. So 3 days after that initial break-in. The only difference in that case is that nothing was stolen from the establishment on that day. Those are the facts and circumstances of the case ending in 1826. For the case ending in 1828-01, if this case were to proceed to trial, the state would show that on July 16th and July 20th of 2025, the defendant entered the property of Savvy Provisions that's located at 988 Peach Streets, Northeast Atlanta, Georgia, also in Fulton County. Kind of the same thing as the first indictment. The defendant used a rock to throw through the large glass window of the establishment. When he went inside of the establishment, he stole a large amount of cigarettes. That first time he went on the 16th, it was in value of less than $500. That time he went on the 20th, he stole a large amount of cigarettes, vapes, and things of that sort, where it exceeded $500. So that's why one theft by shoplifting is a misdemeanor and the other one is a felony. In this case, this break-in on both the 16th and the 20th was captured on surveillance. Those are the facts and circumstances of that indictment. In the indictment ending in 1827, this case were to proceed to trial, the facts would show that on July 13th, 2025, the defendant broke the window or large glass window to the establishment called Urban Hair. That business is located at 77th 12th Street Northeast Atlanta, Georgia, also Fulton County. The surveillance captured him breaking the window, but there is no additional information on if he went inside or if he took anything from that establishment, hence why he's only charged with the criminal damage in this case. And then in that last indictment, Your Honor, ending in 0570, if this case were to proceed to trial, the state would show, or the facts would show, that on July 20th, 2025, the defendant entered the location of Cafe Lucia. It's a restaurant located at 205 12th Street Northeast Atlanta, Georgia, also in Fulton County. There was surveillance at this establishment also that showed the defendant breaking the glass window of this establishment. He went inside of the restaurant where he stole a black iPad, 2 Coca-Cola bottles, and I believe that was all from that establishment. On that same day, Your Honor, he was arrested, not on that same day, my apologies, 4 days later, on July 24th, 2025, the defendant was arrested for all of these charges after the officers were able to look at all of the evidence, look at the video surveillance, and determine that the person who entered into all of these establishments and all of the previous indictments was indeed Mr. Cook. And those are the facts and circumstances of the case ending in 0570. Regarding the recommendation from the state in this case, the state is asking for the defendant to be sentenced to 10 years to serve 3, with the special conditions that it be recommended the defendant in this case complete the RSAT program while incarcerated, as I believe the reasoning for these break-ins was an underlying drug or alcohol abuse problem. The state would also ask for the defendant to complete an anti-theft course, for the defendant to stay away from the incident locations and mentioned in all of the indictments, for the defendant to complete a drug and alcohol evaluation with treatment if necessary. And at this time, Judge, there is restitution to be paid. However, we would ask for it to be reserved until we get a chance to get the documentation for how much restitution would be. But that is all from the state, Your Honor.
Okay. And do you have a recommendation as to what should happen with the revocation? We'll get to that formally, but you can lay it out now.
Yes, Judge. I believe he has around 2 years and some change or months left. I would just be asking to revoke the balance.
Okay. Got it. He does. He has 2 years, 5 months, and some few days after that. All right. Let me find out from Ms. Hutcherson what the criminal history GCIC, NCIC shows for Mr. Cook.
He has 40 cycles, a March of 2024 conviction for 7 counts of burglary, 6 counts of theft by taking, and 1 count of criminal damage to property.
What county is that in?
Fulton County.
Oh, that must be the 23. Okay, got it. Okay.
A 2019 conviction for theft by receiving stolen property, willful obstruction of a law enforcement officer, and fleeing or attempting to elude. A 2015 conviction for 3 counts of burglary. A 2015 conviction for 2 counts of theft by taking. A 2009 conviction for theft by taking and 2 counts of burglary. 6 additional burglary convictions, 2006, 2002, 3 in 1990, and 1 in 1989. A robbery and armed robbery conviction from 1992. And lastly, a 1989 theft by taking conviction. And nothing further to add.
Okay, that was plenty. Thank you. Ms. Smith, no recidivist, anything? I don't know if there's a burglary recidivist statute, or clearly Mr. Cook is a repeat offender. Is any of that in play with this plea?
It is not, Judge. I think with the recommendation, the main concern here was for him to get some type of help when it came to drug and alcohol, which is why we requested the RSAT. But as far as the recidivist notice, no.
Okay, got it. Ms. Wood.
Thank you, Judge. So we had actually tried to get Mr. Cook into drug court earlier this year, but there's so many moving parts. Drug court actually rejected him. Mr. Cook maintains that he was accepted into a program. It's a Must Ministries. He tells me it's an 18-month inpatient program. I reached out to, unfortunately, he had different pre-indictment attorneys due to the number of cases. And so I tried to gather up as much information from our social workers and those attorneys as I could. I personally don't have the acceptance letter, but he did want me to share with the court that he does have a bed there. He's asking the court to sentence him to 10 years probation to serve the first year in custody. He does have mental health diagnosis, and he has been self-medicating with illegal substances. So he does have those struggles. And so that is our request on these cases, Judge.
Okay. Mr. Cook, I will turn to you in just a second. Ms. Simpson, I'm looking at the 23SC case that we'll be handling as a revocation. That was with me. And Mr. Cook was given 1 year and 3 months to serve, followed by a bunch of probation, 6 years of probation. But one of the conditions of probation was complete RSAT aftercare. So I'm wondering if you have anywhere in your system that Mr. Cook's already done RSAT. It's an odd condition to have.
If you would give me a moment, Judge, let me check into that.
Okay. Mr. Cook, I'm going to chat with you a bit while Ms. Simpson is researching that. Do you have any questions about anything Ms. Smith or your lawyer, Ms. Wood, has said?
No, sir, but I do have the acceptance letter here with me if it needs to be faxed or something.
This is from Must Ministries?
Yes, 18-month GAR approved program.
Okay. No, I'm glad you've got that, and that shows some good initiative on your part that you helped track that down. But you don't have any questions about what we've been discussing so far?
No, sir.
Okay. Anything you want to add other than you've got the letter of acceptance?
Yes, this has been a too long of a cycle. This is since I was a child, drug addict. And I'm old, I'm tired, I'm beat up, and I'm done.
Okay, I hope that's true. You ought to feel old, tired, and beat up. The part I don't control is whether you're done, because at the ripe old age of 62, you were making life pretty complicated for Savvy Provisions and Geno's and Cafe Lucia, et cetera. So you got some kick in you left. Mr. Cook, I find that there's a factual basis for each of your pleas. You were clearly working through some things last July and in desperate need of money. The good news is you weren't hurting people. You were hurting businesses and the people who run those businesses, but you weren't out there sticking a gun in someone's ribs and taking their money that way. It was when no one was around, breaking in, that kind of thing, to support the addiction that you wrestle with. I also find that your pleas are knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter these pleas. Do you agree with that?
Yes, sir.
Okay. Ms. Wood, do you authorize someone in my office to sign on your behalf as well as your client's behalf all 4 indictments?
Yes, Judge.
And Ms. Smith, can someone sign for you?
Yes, Judge.
All right, we'll handle that. So I need to hear back from Ms. Simpson before I can go any further. Ms. Simpson?
Judge, it appears he may have possibly completed it. He went into custody in August, right after he was sentenced on the 23 SC case.
Yep.
And he was released in November upon completion.
Okay. Mr. Cook, did you do RSAT with probation? Tell me what you did when your case that you had with me back a couple years ago, you didn't get released right away. You were in custody a little while longer. What happened?
I was mandated to go to RSAP, but was never put in the program and maxed out my sentence.
Did anyone tell you why you were not put in the program?
No, sir. That's the one thing that I'm trying to get help in the treatment, and that's one thing this Better Way Ministries has got is GAR approved. So that's where my heart's at.
Okay. Well, I'm glad your heart is there, and I'm frustrated. It's not your fault. I'm not frustrated with you. I'm just frustrated with the process that you did not get into RSAT during your last stint in custody. Hopefully, we can do better. All right, Mr. Cook, I will go in numerical order with the indictments. So starting with 26 SC 000570, your sentence as to count 1 is 8 years to serve 3 years with the balance on probation. Count 2 is 3 years to serve. It'll run concurrently with count 1. You will, as a special, when you are released, Mr. Cook, where do you plan on living?
Better Way Ministries.
Okay.
After I complete the program.
Got it. And tell me, where are they?
They're in Sonoya, Georgia, outside.
Got it. Okay. So a special condition of your probation will be to stay out of Fulton County. Sonoya is not in Fulton, so you can definitely go there. You will also, well, that's going to be the situation, is that you stay out of Fulton County. I will recommend to the Georgia Department of Corrections that they get you in the RSAT program. I can't force them what to do, but I can certainly recommend it. And I'm hoping that if they engage you down at Jackson about your needs, you let them know that you'll take any kind of drug treatment. That doesn't mean you also can't do Better Way. I think it's great to do both because Better Way would be a good entree back into society. In 26 SC 001826, your sentences to count 1 is 8 years to serve 3 years. Count 2 is 3 years. Count 3 is a misdemeanor if you take less than $1,500 of property, Ms. Smith?
Yes.
It is. All right, 12 months to serve. Count 4 is 8 to serve 3, and count 5 is 3 years to serve. Those all run concurrently with each other and concurrently with the case ending in 570. In 26 SC 001827, your sentence is 3 years to serve. That'll run concurrently with all the other sentences we've been talking about. And finally, in 26 SC 001828-01, count 1 is 8 years to serve 3 years. 2 is 3 years to serve. 3 is 12 months to serve. 4 is 8 years to serve 3 years. 5 is 3 years to serve. And 6 is 3 years to serve. They'll all run concurrently with each other. Same condition of probation, stay out of Fulton County. And in all those cases, I will recommend that you participate in the Georgia Department of Corrections RSAT program, which brings us finally to case 23 SC 190975. And I will revoke your remaining probation and have that run concurrently with your sentence in this case. Sentences in these cases. And Mr. Cook, importantly, you get credit for, you've been in for a long time waiting to resolve these many cases, and you'll get credit for all those days. It's a little over 8 months for which you will get credit.
I've got it.
Hold on one second. Let me make sure. Ms. Smith, anything from you?
Nothing further. Thank you.
All right. Did I already ask about signing the indictments?
Yes, Judge.
Great. All right. Ms. Wood. Well, before I get to you, Ms. Wood, Mr. Cook, did you have a question or?
I have 3 months on the other side of ACDC, along with this side over here.
Okay, but you get credit for all that.
So am I being mandated to the program too by you?
No, I'm going to leave that up to you because you may, upon your release, feel like you want to plug into a different program. So I don't need to mandate it. Your heart and mind can get you there if you want to do that. They will be no less accepting of you if I don't mandate it, but I want to give you the flexibility after you're released to do the program of your choice. There may be some aftercare that the Department of Corrections lines up that you'd rather do, but I certainly endorse and embrace the notion of you going to Better Way Ministries when you're released.
Okay, thank you.
You bet. Ms. Wood, anything else?
No, Your Honor, thank you.
All right. Mr. Cook, you are good to go. Thank you.
Thank you.
Your other ACDC case, Ms. Wood, maybe isn't this complicated?
It's not, Judge. It's a negotiated plea into accountability court.
Okay, and that is with?
Miss Brianna Prather. She's
Great, Ms. Prather, if you'd come on up, please.
position 9.
Thank you. All right. Let's get on the record with your case, Ms. Prather. And Ms. Wood, Ms. Prather's already been accepted. I'm just looking at what the charge is here.
Yes, Judge, she was accepted. And this is Miss Williams' case. I think she's on the call.
She is.
Yeah.
Good morning, Ms. Williams.
Good morning.
But yes, she was accepted. And so we, Miss Williams and I just now completed the paperwork. So I'm going to get that over to the team now.
Excellent. Okay. Then let's get on the record. This is 26 SC 001903, State versus Brianna Prather. The state is represented by Ms. Williams. Ms. Prather is represented by Ms. Wood. Ms. Prather, I'm Judge McBurney, and sounds like you are ready to resolve your case so that you can get into some treatment. Is that correct?
That's correct.
Excellent. All right. Well, a couple things before I hand it over to Ms. Williams. Ms. Prather, you have a right to be here in court, which is a public space, but you are appearing from the city jail. Are you all right with that setup?
Yes, sir.
You also have a right to have Ms. Wood by your side for this plea, but we've got a different setup today. Are you all right with that setup?
Yes.
Ms. Williams is about to put you under oath. She will then ask you questions about your rights, about your case. You need to answer those questions truthfully and completely. You also need to let me know if at any point you're having trouble hearing us because there's a technical issue, or if you have any questions about what's going on. Will you do that?
Yes, sir.
All right, Ms. Williams.
Thank you, Your Honor. Ms. Prather, I'm going to ask you a long series of questions, and that's just to ensure that you understand all of the rights that you're giving up by entering a plea today, okay? Could you please raise your right hand? Do you affirm that the testimony you shall give in the matter currently before this court shall be the truth under penalty of perjury?
Yes, ma'am.
You may lower your hand. Could you please say and spell for the record your full legal name?
Brianna Rose Prather, and it's Breanna, middle name Rose, last name P as in Paul, RA, T as in Tom, HER.
Thank you, ma'am. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you?
I'm 39.
What is the highest level of education that you have completed?
I have a bachelor's.
Okay. Are you therefore able to read, write, and understand the English language?
Yes.
Ms. Wood, on behalf of your client, do you waive formal reading of the indictment?
We do.
Ms. Prather, do you understand that as to indictment 26 SC 001903, you are charged with cruelty to children in the first degree?
Yes, ma'am.
Have you had an opportunity to review or discuss with your attorney the rights that you are giving up by entering a plea of guilty today?
Yes.
Have you had enough time to speak with your lawyer, Ms. Wood, about all the facts and circumstances known to you regarding the charges in the indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with Ms. Wood?
No, ma'am.
Are you satisfied with her services?
Absolutely.
Ms. Wood, on behalf of your client and for the purposes of this plea, do you waive any and all defects in the indictment, including any with respect to her name?
So waived.
Thank you. Ms. Prather, have you been arrested on these charges?
Yes.
Ms. Wood, the state is unaware of any outstanding warrants related to these charges. Do you know of any?
We do not.
Ms. Prather, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes.
And for the record, cruelty to children in the first degree carries a sentence range of 5 to 20 years. Ms. Prather, do you understand that this is a negotiated plea of guilty, which means that the state and your attorney will make a sentence recommendation to the court, but the court does not have to accept that recommendation? The court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other.
Yes, I understand.
Okay.
Your Honor, as to the terms of the recommendation, as Ms. Wood stated, Ms. Prather is entering a plea into accountability court with 10 years of probation and the following special conditions: that she complete accountability court, that she have no drugs, no alcohol, that she complete a Fourth Amendment waiver, that she have no violent contact with children, and that she fully complies with any parenting or reunification plan put in place. Any visitation and custody issues shall be governed by the appropriate governing body, which to my understanding is the Indian Child Welfare Authority. Those are the terms of the agreement, Ms. Prather. Having heard these terms, do you wish to proceed with the plea?
Yes, ma'am.
Ma'am, hopefully you will never receive any other conviction, but I would like to make clear that if you ever do receive another conviction, that having entered this plea could be used to enhance or increase sentencing on any future conviction that you receive in the state of Georgia, any other state, any other jurisdiction, including the federal courts. Do you understand?
Yes, yes, ma'am.
Are you currently on probation or parole?
No.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
I understand.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, and or your right to receive, possess, or transport a firearm.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Ms. Wood, were we attempting to use any type of special treatment on this plea that I took over?
So I think she qualifies for first offender. I was going to request that, but I don't have her NCIC. I only have the GCIC. So if we could just confirm at the appropriate time if she qualifies, I am asking for that.
Okay, I will go ahead and go over the first offender portion in that
Thank
case.
you.
Ms. Prather, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Have you ever pled guilty, no contest to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
Yes, in North Dakota.
So that was my question, because when I asked her about it, there was the thought that it might have been part of a diversion that she completed treatment. So that's why I was trying to understand if there was actual conviction or diversion.
Okay, so I'll complete going over this portion and then we'll have that confirmation later.
Perfect, thank you.
So Ms. Prather, just in the event that you might qualify, I'm going to continue to go over this section with you about first offender treatment. And then we will have confirmation from Madam Pretrial if you actually qualify, okay?
Okay.
All right. Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has Ms. Wood, your attorney, explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge in this indictment?
I understand. Yes, ma'am.
Okay. If you are eligible, do you still wish to proceed with first offender treatment?
Yes.
I'm now going to go over the individual rights that you are waiving. Do you understand that you do have the right to plead not guilty?
Yes. Yes, ma'am.
Do you understand that if you plead not guilty, this matter could proceed to trial?
Yes, ma'am.
Do you understand that by entering a plea of guilty, you waive any and all defenses, including but not limited to any mental health defenses and any assertions of self-defense?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? Do you understand that you are giving up the right to trial by jury?
Yes.
Do you understand that you are giving up the right to remain silent and not incriminate yourself?
Yes.
Do you understand that you are giving up the right to confront witnesses against you?
Yes.
Do you understand that you are giving up the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case?
Yes.
Do you understand that you are giving up the right to the presumption of innocence?
Yes.
Do you understand that you are giving up the right to testify on your own behalf and to present other evidence?
Yes.
Do you understand that you are giving up the right to subpoena witnesses and compel the production of evidence?
Yes.
Do you understand that you are additionally giving up the right to have the charges against you proved by the state beyond a reasonable doubt?
Yes.
And finally, do you understand that you are giving up the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
As to indictment number 26SC001903, how do you plead to the charge of cruelty to children in the first degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Please understand you do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA Section 5-6-35, and Ms. Wood can further explain that to you. Do you understand that you have from today until the end of the current term of court to file a motion? Well, actually, let me withdraw that. Do you understand that Judge McBurney actually is going to go over with you your ability to withdraw your guilty plea if you have one?
Yes. Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Do you understand that the appeals and filings that we have just discussed must be filed by your attorney unless you are representing yourself?
Yes. Yes, ma'am.
Okay. Do you understand that unless your attorney, Ms. Wood, is substituted or permitted to withdraw, she will represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes.
Ms. Prather, that concludes all the questions and information that I have for you. I will now turn to allowing Madam Pretrial to go over your criminal history.
Ms. Hutcherson?
I'm here, sorry. I thought I heard my name.
You did. Well, you were referred to as Madam Pretrial, but that's your alias.
Okay.
I'm sorry.
That's
No,
okay.
you're fine. I show a total of 9 cycles, 2 out of Georgia, 6 out of Minnesota, and 1 out of North Dakota. The arrest out of North Dakota was for simple assault, domestic. It's listed as a misdemeanor, but the conviction was 2 years probation. And then she did have 2 convictions out of Minnesota, which I believe were both misdemeanors for driving while impaired, 2012 and 2015. And nothing further.
All right. Thank you.
Your Honor, I can at this point provide a factual basis for the plea.
Please.
On March 22nd, 2026, East Point police officers responded to 1901 Dunlap Dunlap Avenue. That is in East Point, Georgia. That is within the bounds of Fulton County. Officers made contact with a young child whose initials are JP. And he explained that he had been within the residence for at least 2 days by himself. He said that his mother, the defendant, had left him there. Officers did conduct a safety sweep. No other residents or adults were inside the apartment. They did note that the condition of the apartment was unacceptable. Additional officers were summoned to the location, and the officers attempted to get in contact with several adults in JP's life, including his grandfather. And at some point, he was taken to the hospital and checked out. Officers were able to make contact with JP's older sisters. And from there, he was turned over to his older sisters, and they made contact with Miss Prather, the defendant, at some point later, and took her into custody.
And I may have missed this part. How old was JP? It's only a few months ago. How old is JP?
JP is
10.
Miss Prather is saying 10.
Okay. So he was home alone, said he had been home alone for a couple days. The house was a mess. The allegation is that he didn't have enough food, basically. Was that part of the issue, or?
Yes, Your Honor, that he was really too young to have been left by himself for that length of time. After having spoken with JP's older sister, officers were able to confirm that it had been a couple of days since Ms. Prather had been in contact with JP, and then based, of course, on the condition of the apartment as well.
Okay. And did Ms. Prather say anything to law enforcement about what had been going on that is in your records?
No, Your Honor, I have not reviewed any statements by Ms. Prather. I believe that she did provide some information about the last time that she had been in contact with him, based on an Uber. So there was that exchange between Ms. Prather and police.
Okay. Got it. All right. Ms. Wood.
Thank you, Judge. So just to add like a little bit of context. So yes, so the officers got the call from the neighbor who said that he heard yelling. They showed up to the apartment complex. There was like spoiled milk sitting outside of the door. They knocked on the door, and JP answered, and he told officers, like, he was really scared. He was crying. I'm just a kid. Like, he was alarmed by officer being at his door. And so yes, when they went into the apartment, they were concerned about the fact that he was home alone at that age. He instructed the officers that he was preparing microwave meals for himself. They were concerned that some of the food was expired. It's my understanding from speaking with Ms. Prather that one of her adult daughters was supposed to be providing care for him while she was away. There's also mention in the police report of a man by the name of Mr. Brandon supposed to be helping with caregiving at the time. In any event, no adults were on the scene at the time the police were called. And so here we are. Judge, she's 38 years old. As you heard, she has a bachelor's degree, so she's college educated. She was working in home health care prior to this arrest. She lost that job due to this case. She has 3 children total. So she has 2 adult daughters, and then she's got the 10-year-old son. She's originally from Indianapolis, although she's lived here in Atlanta for the past 10 years. Judge, alcohol is her drug of choice. We had actually, when we submitted the referral, our team had thought that she would be more appropriate for drug court, but they did their evaluation and thought that behavioral health treatment court is actually more appropriate. And so we're excited that she was accepted into that program. She was sober for 8 years, and then she relapsed recently on the anniversary of her mother's death. And so we are hoping that accountability court will help her get back on track. JP is actually in the custody of her sister who lives in Minnesota. The sister has temporary parental rights. The family is hopeful that once she completes programming and gets back into a life of sobriety, that she will be able to work towards regaining custody. So that's what I did want to share with the court. She has been in custody 86 days. I am asking for first offender treatment. I think she qualifies, but I'm not sure about that simple assault, although that does sound like a misdemeanor. So I am requesting first offender treatment. And then if a behavioral incentive date after successful completion of the program is a possibility, I would request that as well. And that is all. Oh, and she wanted me to tell the court she completed the STAND program while she's been in custody. So we're very proud of her for that, Judge.
Excellent. Okay, that's good to hear. So, Ms. Wood, you can answer, or Ms. Prather can answer. When this happened and JP was effectively home alone, I appreciate that maybe an adult daughter was supposed to check on him or this mysterious Mr. Brandon, but mom was in charge. It's her son. When she was absent for a couple of days, was this in the midst of the relapse? And so she was struggling in her own way, or she was fine and just decided she didn't need to check in?
I think it was, but I'll let her clarify, Judge.
Okay.
It was in the midst of a relapse, and I was working at the time. I was working nights too. So, but yes, I take full responsibility for it. My daughter was supposed to be there. It is still my responsibility. Definitely.
Okay. All right. And your son is now with your sister back in Minnesota?
Yes.
Okay. All right. Are you able to, well, I guess you are in custody now. Have you been able to speak with him, or is that not allowed, or how does that work?
I was told no contact. So.
Okay. That won't be the case after sentencing. So after today, you will be able to have contact with him. Are we going to release Ms. Prather directly to accountability court?
That is my request, Judge.
Okay, so we'll do that. Ms. Prather, do you have a place to stay, or do you need housing through accountability court?
I still have my apartment.
How is that being paid for? You've been out of circulation for almost 3 months.
I'm on Section 8 and I was on zero income, so they were paying my rent.
Okay.
Yeah.
All right. So you have a place to go back to. Is that a location that is consistent with you being sober, or is there a problem going back there?
There's no issue going back there. I can stay sober.
Okay.
I like being sober.
Good. We like you being sober too. I just want to make sure we're setting you up for success as best we can as you get started with BHTC. Do you have any questions, Ms. Prather, about anything that's been discussed?
So I'm being released to accountability court. What does that look like? I'm just gonna get released and have to report to them, or are they gonna come and get me?
The second. Orientation is Tuesdays with accountability court. So if we get all our paperwork aligned on Tuesday, so a week from yesterday, they should come pick you up. And they will take you to Hope Hall. That is where all the accountability courts meet. You'll get orientation, and then Tuesday afternoon or evening, you'll go home. You will go to your residence. And you will receive on that Tuesday all the instructions about here's when you need to be back. And the answer will be the next day, because early on you'll be going to Hope Hall every day. But rather than just releasing you to the street and hoping you show up at Hope Hall, I am deciding, but it's what accountability court would want anyway. So you're going to stay put until, their next orientation, which will be, as I said, next Tuesday. So they'll pick you up on Tuesday, and you'll get started with that program.
Okay.
Any other questions?
No, sir. Thank you.
Okay. Well, Ms. Prather, I find there's a factual basis for your plea. I better understand what this is. The indictment as it reads sounded pretty grim, but this was more of a neglect than that JP he weighed 10 pounds as a 10-year-old. Sounds like he had plenty of junk food to eat. It just, there wasn't a parent there to help him out. He was only 10. And you'll work through that better going forward. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one's forcing you to enter this plea. Do you agree with that?
Yes.
Okay. Ms. Wood, may someone in my office sign on your behalf and Ms. Prather's behalf the indictment?
Yes, Judge.
And for you, Ms. Williams?
Yes, Judge.
All right, we'll get that taken care of. I'm going to table the question of first offender. I am open to amending the sentence, but homework project for your office, Ms. Wood. Someone needs to get in touch with North Dakota and get that paperwork sent to you, to Ms. Williams, and to me, just so we can reconcile the 2 years probation versus misdemeanor. My guess is it was 2 misdemeanors and it was 24 months probation, but we all think of simple assault as being a misdemeanor. It may be that in North Dakota it's not, and that's why probation was 2 years. I just don't want to impose an illegal sentence, and I am not familiar with North Dakota criminal law. So if you could get that, if the paperwork checks out, then I will amend the sentence to make it a first offender sentence. For now, it's not a first offender sentence. Ms. Prather, I'm going to sentence you to 8 years probation, but actually, and I'm going to sentence you to 8 years to serve 2 months with a balance on probation. So 8 years to serve 2 months. You've already done the 2 months. You've done a little more than that. Special condition of probation number 1 is that you enter into and successfully complete behavioral health treatment court. Special condition number 2 is that you comply with all parenting plans that are established concerning your parentage of your son. And then finally, there'll be a Fourth Amendment waiver so that if probation or folks from accountability court need to search your apartment or your car or whatever, they don't need to come to me to get a warrant. They can make sure everything is on the up and up. So 8 years to serve 2 months, balance probated, and the main project is your sobriety, which is you getting through behavioral health treatment court. Do you have any questions about any of that, Ms. Prather?
No, sir. Thank you.
Okay. Now, like I said, I'm happy to make that a first offender sentence after we get paperwork from North Dakota, if that clears things up. And it's going to say on the final disposition that you'll be released via separate order. And there will be an order that gets the accountability court folks to come pick you up and get you to orientation on Tuesday. Okay. Ms. Williams, anything else from the state?
No, Your Honor, nothing further from the state.
Ms. Wood, anything else on behalf of Ms. Prather?
No, Judge. Thank you so much.
All right. Good luck, Ms. Prather.
Thank you.
Judge, can I
Oh, yes, I forgot. You'll be on probation, and that voice you're hearing is Ms. Simpson with probation. You are going to need to report to probation. You will be much more focused on accountability court, but there is a probation component. Ms. Simpson?
So Judge is correct, Ms. Prather. While you are actively in behavioral health treatment court, you will not be required to report to probation until you graduate. If by any circumstances that you are terminated, you will then be instructed upon your revocation, you will be instructed to report to us. But as long as you are actively in the program, you do not have to report until you graduate.
Okay.
Thank you.
Thank you.
All right. Thanks, Ms. Simpson. Is that it, Ms. Williams? You got anything else, or is that your case?
I think that's my case, Your Honor, if I may be excused.
Have a great day.
Thank you. You too.
All right.
You're right. We have 2 more, Butts and Jones.
Right. We're doing those next. Those, I believe, would be Ms. Rios's cases. All right. Mr. Jones, why don't you come on up? Ms. Rios, you ready?
Yes, Your Honor. I filed a little late, but I filed a motion to set aside his bench warrant. I believe I also filed a waiver.
Okay. I have down that we are going to talk about setting aside the bench warrant. So let me get into Mr. Jones's case. Position 22. All right. We do not need to be on the record here. 137. yes, you filed a waiver. And Ms. Nelson had already included the motion. So, Mr. Jones, I'm Judge McBurney. You are charged with aggravated assault and a few other counts. You missed court when we had plea and arraignment in January. I signed a bench warrant in January, and I guess that bench warrant caught up with you in May. You got arrested in mid-May, and we are going to talk today about whether I ought to keep you in custody because you missed court, or if we ought to lift the bench warrant so that you can get back out. Tell me, Ms. Rios, why you think Mr. Jones didn't make it.
He did not receive notice. It was sent to the wrong address. He said he did call the Superior Court and updated his address, and he doesn't know why it was never updated. And so just as I have a new address for him, and I'll do a change of address right after we are done with court. But that was the issue. He said I think he called more than once to see why, to make sure it was changed, but it just never changed.
Okay. I'm looking at the notice to see where it went. So, Mr. Jones, what's the street name that's the good address now?
It's 606 Briar Hill Lane, Riverdale.
Briardale?
Briar Hill, BRIAR.
Briar Hill, okay. Briar Hill, where did you live before?
Before I lived at 5100 High Point Road, and then I moved with my grandmother at 5502 Rock Lake Drive.
Okay, so the notice that was sent out telling you to be in court in January was sent to the High Point Road apartment in Union City. When did you move out of there?
I moved out of there when I got arrested, and the judge told me not to return back to the address, so I moved to 5502 Rock Lake Drive.
Oh, well, that was a good thing you moved. So you had a bond that said don't be there?
Yes, sir.
Let's look at your bond. Yep, stay away from that. Okay, that's where you had been living?
Yes, sir, that was my apartment.
Okay, and you're supposed to stay away from someone whose last name is Ponder. Who is that to you?
That's my right now my spouse.
Oh, well, that's awkward. So you're supposed to stay away from her while on bond?
Yes, sir.
Okay, all right. So you have a place to go. It's the address that you just mentioned, and that's not where your spouse lives?
No, sir.
Pardon me?
Yeah, that's where I live, but that's not where she lives. She lives in Decatur. Her dad.
Got it. Do you two have kids?
Yes, sir.
How many?
I have 2 biological kids with her and a stepdaughter that I took in when I was in a relationship with her. But as
Got it. Okay. Ms. Smith, do you have thoughts about what to do in this situation?
Yes, Judge. For starters, this is Ms. Willingham's case. I know it says my name on the calendar, but this will be her assigned case. However, I do have a announcement from her, and she just said that she defers to the court on if that bench warrant will be set aside or not.
Thank you for covering. She did send a text saying that she had to sign out. I just didn't know which case was hers. Okay. Let me check one other thing about Mr. Jones, and then we can figure out. Ms. Rios, do you have any information about whether the bonding company has surrendered the bond or not?
I do not. I don't think they have. When I look, let me double check in Odyssey. But I know sometimes it doesn't show me for sure.
Yeah, it doesn't show.
Yeah, I don't know if we could do this. I know she's Miss Williams is not here. If they did come off, can we do a new bond?
Well, what I'll do is, I think we have a way of checking with the jail to see if they surrendered the bond. So I'll do that. We'll confirm. If the bond is still good, then I just lift the bench warrant and Mr. Jones is on that same bond with those same conditions. Stay away from that address and for now, stay away from his spouse.
And I probably, just a heads up, might be filing a motion to maybe alter those bond conditions because I believe she keeps reaching out to me and wants contact, but I'll double check. Yeah.
Got it. And I mean, you know how that flows. You'll want to talk with Ms. Willingham. Obviously, Ms. Willingham will want to talk with Ms. Ponder, and there may be a middle ground that we can get in place. But for now, Mr. Jones, assuming you are released, you will need to continue to stay away from Ms. Ponder. Ms. Rios may explore the option of you guys being able to have nonviolent contact or telephonic contact or who knows what. But I will set aside the bench warrant. And before I do that, I just need to know if the bond is in place. If it's not, then I will set a new bond. Ms. Smith, anything else on behalf of the state?
Nothing further, thank you.
Okay. Ms. Rios, anything else? We'll get a scheduling order in since you waived arraignment.
Nothing further. Thank you, Your Honor.
So Mr. Jones, you'll know things went well if you're released. If you're not released after a few days, reach out to Ms. Rios and she can let you know what the hiccup is. But it's my intention to get you back out on bond. And it's real important that you keep Ms. Rios updated with your address if you should need to move so she can get it in the system, okay?
Yes, sir.
All right, and Ms. Rios, I don't see a change of address in the system.
I'm going to file that today.
You'll do that today. Okay, so we'll have a COA, there's a waiver and a scheduling order, and we'll check on the bond. Okay. Anything else on behalf of Mr. Jones, Ms. Rios?
No, Your Honor. Thank you.
All right, Mr. Jones, you're good to go.
Thank you.
All right, we'll handle Ms. Butts' revocation in just a second. You don't look like the defendant.
No, Judge. Good morning.
Good morning.
Brown with the Public Defender's Office.
Hey.
We have Mr. Lewis downstairs. He was terminated from your drug court, I believe, and we're just unsure if
What's going on?
giving him a new bond on this case will release him. There's an FTA on it that was issued by your court, I believe.
You got my check? Man, one second.
The judge.
Say that last part?
We're in 1B with Judge Ashley.
Got it. Oh, he has new charges?
Mm-hmm. And they were terminated from drug court, was my understanding.
I'm looking at his other cases. Yeah, all his cases were diversionary. I think he had an unindicted case. He also has an indicted case that is now back with non-complex. And I don't know what that judge wants to do about bond. I didn't revoke bond or anything. There wasn't a probation to revoke because they were all either pre-indictment or pre-resolution. So if the question is, should he get a bond?
The question is more so regarding the FTA that's currently holding him on an unindicted or a pre-indicted case.
Okay.
Because it was issued by drug court. We're unsure if our set aside will set it aside.
Okay.
So I guess do you need to file the set aside or can we file it
And the FTA is in connection with the PI number you put right here. Okay. 1980. So you filed the motion for bond and the substitution of counsel after it returned to the world of unindicted cases. Okay. I think, yes, Judge Ashley can set it aside in his discretion, but there is no more drug court for Mr. Lewis to report to. So we've dealt with his situation, which was you're terminated, and then it was up to the discretion of Judge Ashley for the unindicted cases, and I think it's Judge Mao, but one of the non-complex docket judges to decide if there were going to be bail consequences to the termination from drug court. Does that help?
Yeah.
Okay. All right. Thanks for checking. All right, sorry for the delay. We are going to talk about Ms. Butts's case now. Good morning, Ms. Butts.
Good morning.
So I'm Judge McBurney, and we're going to get on the record in your case. It is 18 SC 159425. It's a case that you pled guilty to a while ago, where you were charged with robbery. And let me find one more piece of information. Here we go. Looks like you actually have a second older case, a 15 SC case. We'll handle both of them. But you've got a little more than 5 months left on probation in these two cases. I signed a warrant, a probation warrant, in your 18 SC case, that alleged that in December of last year, you picked up a shoplifting charge in DeKalb. And there's a petition that says the same thing, shoplifting charge in DeKalb. So we need to work through what the consequences are of that. Ms. Rios, have you and Ms. Butts had a chance to talk about this?
Yes, Your Honor.
Okay, and are we going forward with a revocation, or does Ms. Butts want an evidentiary hearing?
We're going to go forward with the revocation.
Okay, what is your recommendation?
Yes, Your Honor. Ms. Butts, 31 years old. She's has been in custody, I think, for about a few months now. I have to look at the date that she's been in, but she has 3 children that she needs to get home to, ages 12, 10, and 8. She was working for SK Packaging in Fulton. She is a life resident of Georgia, and she did obtain her GED. She completed some of the anger management class that she was supposed to complete. I'm asking to revoke the time that she's been in and terminate the balance, because I believe she only has 7 more months on probation. And I don't believe that she's had many revocations. She's been doing pretty well from my understanding on probation. I believe probation was just asking to revoke the time she's been in, I believe so, and then terminate the balance also. So I'm asking that you go along with that recommendation.
All right, Ms. Smith, your thoughts?
Yes, Judge. In this case, the state will be asking to revoke the balance, which is around 5 months and some days. The reason why we're asking to revoke the balance is because although the defendant pled to both of these cases in 2019, 6 to 7 years later, there's kind of the same type of behavior happening where something is being taken from someone or stolen. That's kind of similar to the charges that she has from that she pled guilty to back in 2019. So because of the risk to reoffend, as she's reoffended in this case, the state would be asking to revoke the balance.
Okay. I'm looking up the 15 SC case as well. Yep, it was a plea in front of Judge Reeder on the same day. And that was sounded like a fraud type case, forgery, identity theft, etc. Okay. Ms. Simpson, what is the Department of Community Supervision's view?
Yes, Judge. So given the fact that this is Ms. Butt's first revocation, since she pled to both cases, my recommendation was to revoke 60 days, which is estimated, I believe, the time that she's been in custody, and to terminate the balance on both cases.
And the status, this was in your email, the DeKalb case is pending, but Ms. Butts has posted bond. Okay, is that right, Ms. Butts? You've made bond in DeKalb, so what's holding you is this situation?
Yes.
Okay, when you are done with your revocation, do you have a place to stay?
Yes, I stay here in Fulton County.
Okay, is that where your kids are?
Yes.
Who is taking care of them the last couple months?
My mom.
Okay. And do you all stay together or they are temporarily staying with her?
Before I got locked up, I had my own place, but due to me being locked up, I don't have that place no more. So I'll be with my mom until I move into my own place.
Okay. And what kind of work will you do when you get out?
The job I was at before I got locked up was CSK Packaging, and it's like a second chance job. And I had my mom speak with them, and they are willing to let me come back.
Okay. That's the place that makes bottles and things like that?
Yeah, I'm Fulton Industry, yeah.
Yeah, no, they're a great second chance employer. We use them. There are people from accountability court who get jobs there, and it's tough work, but they pay, you get benefits after a while. I hope you stick with it. How do you get from your place to there? You have a car or is it public transportation?
No, I have a car, and it was close by. It's like 10 minutes from where I was staying, so it's not far.
Okay, all right. Well, that's good to hear. Anything more you want to add?
No, not really.
Okay. Well, Ms. Butts, I fall somewhere in between Ms. Smith's view, which is, hey, how could you be back at something like this? There need to be consequences. And I also appreciate Ms. Simpson's observation that you actually were on probation for a long time and did a great job. And that needs to be recognized as well. So what I'm going to do is revoke 3 months of your probation. You will get credit for the time that you've been in, and then I will terminate the balance. So when you are released, you will not be on probation anymore. You'll still have your DeKalb case. You got to deal with that. Don't skip on that. But these 2 cases that have been following you around for years and years and years will go away, and then you deal with DeKalb in whatever way you and your lawyer there does. But you'll be done with your 2 Fulton cases. So when you're released, you don't need to report to probation. You need to report to your mom and your kids and get your job back. All right?
Okay, thank you.
Ms. Rios, anything else?
No, Your Honor, thank you.
Ms. Smith?
Nothing further. Thank you.
All right. And Ms. Simpson, do you have what you need for the paperwork?
Yes, Judge.
All right. Thank you, everyone. And thank you, ACDC. You were very patient. Boy, we're on with ACDC for a long time.
You're welcome, Your Honor. Thank you for everything.
All right. Bye-bye.
Bye, everybody.
All right. We're going to pivot to the county jail. I just need to send one email. All right. Positions 1 and 2, Ms. Smith, Mr. Laval, he is on loan out to the Marshal Service. And Ms. Nelson reminded me, we're supposed to get an update from you. I don't know if update's the right word, but have you been nudging anyone in the U.S. Attorney's Office? Do you have a sense of what's happening with Mr. Laval?
The last time I spoke about this case, Ms. Wood sent an email saying that she spoke with someone at the Marshalls. They said they tend to keep them for a longer period of time. I haven't been able to speak with anybody there, but I'll have Miss, oh, I forgot her name. I will have someone reach out to see that we can to see when we'll be able to get Mr. Laval.
Okay. The name is the same name as a TV reporter, but I'm blanking on the name.
Farm? Is it Miss Farm?
Yes,
Ms.
yes.
Vaughn.
Should we put these cases on judicial hold because he's unavailable? Or should we keep bugging you about them?
Yes, Judge, I would like for position 2 to be placed in judicial hold. I did submit a no prouse order for position 1. So if position 2 could be placed in judicial hold, that'd be great.
All right, we will make that happen. Ms. Wood, anything you want to add about Mr. Laval?
No, Judge, only that, so he's technically pro se. I know Mr. Dobbs worked with him on that motion to suppress.
Oh, right, that's this case, and that's gone. You did submit the null pros on that. I've taken care of that, so that one's gone.
But I will keep, so he's pro se, but I do have a file for him. And I don't know if you remember Edward Cherry, but he was a gentleman who had a bunch of stuff going on and he was in and out of our jail. I'll just keep an eye on Mr. Laval since it'll be in judicial hold. And then if I see him come back into our jail for a period of time, I'll let Ms. Smith know.
I definitely remember Mr. Cherry. What is the connection between Mr. Cherry and Mr. Laval?
Oh, there's not a connection, Judge. I was just using that as an example. Mr. Cherry was like back and forth with the feds and Clayton and
Right.
yes.
He was a busy man. Right. Okay. That gets us to Israel Bird. Let me find that booth and get it going. I hope people haven't left. There he is. Mr. Abadi, I tried sending you a chat, but I think it went to you were logged on in a different way. The Sean Johnson case isn't happening today. You there? Mr. Shart represents him and he filed a waiver. And so Mr. Shart was excused and we didn't have Mr. Johnson brought to a booth.
Judge, I believe that's also Ms. Willingham's case. I got a message from her saying that she did see that the parties were excused for today.
Okay, great. I'm having a little trouble connecting to Mr. Bird's booth to unmute it. So let's see what we can do here. Hey, Mr. Byrd, can you go next door to booth 2 and see if that's open, please? Can you hear me?
Yes, sir.
Excellent. I can hear you. That's much better. So, Mr. Byrd, you are on for plea and arraignment. Ms. Rios, is this your case?
This is going to be a conflict, and I confirmed that the conflict was done a while back. Ms. Cabrera has an older case.
Good morning, Judge.
Hi, Mr. Luemba. Thank you for being on.
Hi, Judge. I'm announcing for Ms. Cabrera. This is going to her. I did send it to her. I'll waive formal arraignment and plead not guilty on her behalf.
Excellent. Thank you. Mr. Byrd, let me check one thing. Your name is familiar.
He's on the multi-co-defendant gang case, Your Honor.
That's what I thought. And who represents him in that?
I believe it is Euphemia or Miss Cabrera.
I think it's Miss Diamore as well, Judge. She represents them on several cases, and I just sent another one to her. So,
all right. So, Mr. Byrd, you've worked with Miss Cabrera before. You know who I'm talking about?
Yes, sir.
Okay, then it's consistent. That's a smart plan in Mr. Luemba. So, Mr. Byrd, you've got new charges. I'm assuming they arose out of your time in custody. They were assigned to me because the larger case is assigned to me. And Ms. Cabrera, who is a colleague of Mr. Luemba's, will be representing you, but Mr. Luemba's helping us move things forward by waiving arraignment and entering a plea of not guilty on your behalf. That triggers the state's obligation to get discovery to Ms. Cabrera. She'll share that with you. And this will just fold into the other work she's doing on your behalf in connection with the larger gang case in which you are involved. Mr. Abadi, anything else on Mr. Byrd's situation?
No, Your Honor.
Okay. Mr. Byrd, do you have any questions about what I just said?
How long is it gonna take for my discovery to get
For the new case?
for both for all of it?
So you haven't had a chance yet to look through the discovery in the gang case?
I don't got nothing.
Okay. All right. Well, I didn't know that. I will get with Ms. Cabrera on that to make sure we either bring you over here. There's a lot of videos and audio to deal with, and that she can't hand that to you. That would be you viewing it. So that may mean we bring you over here, or I get her an order that allows her to bring her equipment into the jail. Mr. Luemba, anything else on behalf of Mr. Byrd / Ms. Cabrera?
No, and as soon as I get off this, I'll call Mr. Cabrera and relay the message from Mr. Byrd, and she'll get on that.
Okay. Mr. Byrd, anything else?
No, sir.
All right, well, we need to get you that paperwork. We'll make it happen. You are good to go. Thank you. Next up, Mr. Moran, is your client, Mr. Denizard. Let me get him on the screen.
Thank you, Your Honor.
Mr. Luemba, do you have anything else on this calendar?
I believe I got a notice about an update from Mr. Chisholm to make sure that he had counsel.
Correct. He is on this calendar for us to confirm that he has a lawyer.
Yes, I filed in about a week and a half ago, Judge.
All right, you are officially his counsel.
Yeah, I filed in about a week and a half ago, and I let Miss Nelson know. There was a little bit of a mix-up because it was going to go to Miss Cabrera, but apparently she represented somebody that knew him some time ago, so it wouldn't have been proper for her to represent him, so I just went ahead and filed in.
Excellent. Well, let me check before we pivot to Mr. Moran's client. We may be able to be done with Mr. Chisholm's situation with that confirmation. So Mr. Milam has judicial hold. Okay. Yep. You've got your entry. All right. It doesn't look like there has been a waiver of anything yet. Do we know, Ms. Nelson, is Mr. Chisholm on? I don't see him listed with a booth.
No, Judge, I'm not sure if he is or not. I sent a waiver to Mr. Mohammed this morning.
Okay, well, I can get that file
Great.
today, Judge. I'm going out of town tonight, but I will be seeing clients at Fulton County Jail before I leave.
Okay.
So I can go ahead and get that filed for the court before 5. I didn't see the waiver, but I'm sure Ms. Nelson sent it. I'll get that filed today, Judge.
Good. If you'll take care of that, then Mr. Chisholm's case can move forward. You're in the system now as his lawyer, so that's step one. Now we just need that waiver, and then we'll do a scheduling order.
Okay, great, Judge.
Thank you, sir.
You're welcome. Bye.
Have a great trip.
You too. All right, well, not you too, but.
All right, let's get Mr. Denizard up. Mr. Denizard, can you hear me?
Hello, yes.
Excellent. I am Judge McBurney. Your case has been assigned to me. Your lawyer is Mr. Moran. He is on this call, and we are going to talk about bond in a moment. I just need to get your case on the screen in front of me.
Yeah, sure.
All right, so Mr. Moran has already waived arraignment. We'll get a scheduling order in place after today's bond hearing. Ms. Smith, is this your case?
It is, Judge.
Are you comfortable talking about bond?
I am.
Great. Then we're going to get on the record. This is 26 SC 001796, State versus Denizard. The state is represented by Ms. Smith. Mr. Denizard is represented by Mr. Moran, who is joining us. And Mr. Denizard, Mr. Moran is going to tell me all the reasons why you should get a bond and what that bond should look like. Then Ms. Smith is going to give me the state's perspective, and I will let you know while we are on this Zoom session what it is I'm going to do. When you're ready, Mr. Moran.
Very well, Judge. Good morning, first of all. There's a preliminary matter that I would like to just address with Ms. Smith and with your honor, and that relates to I've had some conversations with ADA Smith, and it's my understanding that she intends to introduce some photographs that depict injuries to the victim in this case. We're on YouTube, and it's a public platform, and for security concerns and safety concerns for Mr. Denizard, I would ask if the court, we have no objection to the introduction of the photographs, but I would ask if it would be possible for ADA Smith to submit those to the court so that your honor may be able to see those, view those, but without publishing them publicly. So that's just kind of a housekeeping measure. I've discussed this with Ms. Smith. I understand that she wishes to publish them. I object to that for safety and reasons for Mr. Denizard's safety at the Fulton County Jail, and would make that request. If those could be submitted to the court via email, we have no objection to that.
Okay, Ms. Smith, what are your thoughts about Mr. Moran's request?
Yes, Judge, we had a conversation about it earlier, and I told him since I wasn't in person, we're on Zoom today. I would just be during the bond motion publishing the images while we're having our discussion about hearing. But I did the bond hearing, but I did tell him that if the court would ask for the pictures to be sent via email, I could do that also. I'll just defer to the court on if we should show the pictures via Zoom or via email.
Okay. If you have them in digital form, I guess you must if you were going to share them. I'm fine having you email them to me. If Mr. Moran, and just copy Mr. Moran on the email. If you can do it now, I would like to be able to view them contemporaneously as opposed to, well, I'll look at them later and let everyone know what I'm going to do.
Yes, Judge, I'll send those right now.
Okay.
Thank you, Your Honor.
All right, Mr. Moran.
With that, we filed this motion for bond on June 2nd, and I'll give just a little bit of biographical information about Mr. Denizard. This is a 46-year-old gentleman, Your Honor. He has been employed as an audio and video engineer. He has great experience in the film and audio industry until his arrest, which occurred on March 17th. He was gainfully employed, has worked in the film and video industry here in the Atlanta area for years. I have a letter which was going to be a character letter, which I'll share with the court, screen share with the court in a moment, from a former employer of his, Miles Green. Michael, again, today it marks 3 months since he has been in custody on these charges. The charges, as the court knows or sees in the indictment, is 1 count of aggravated assault and 2 counts of battery, as I understand it. All of these relate to 1 incident, 1 night, and 1 victim. The state's victim in this case is a young woman by the name of Madison Thomas, with whom I have met. Ms. Thomas and Mr. Denizard were in a romantic relationship. Michael lived with Ms. Thomas here in the Atlanta area in a condominium where they had been in a relationship for about a year. This is, other than 1 prior cycle, 1 prior arrest, with no convictions. This would have been his first lifetime involvement or criminal offense. As to my knowledge, and I've discussed this with him and with his family, no prior criminal history at all, and again is 46 years of age. This incident happened at Miss Thomas's residence where she and Michael lived together. And quite frankly, I think it would be fair to characterize this as a binge alcohol fueled incident on both parts. Both Ms. Thomas and Mr. Denizard were extremely intoxicated when this happened. On March 29th, Judge, which is about 12 days after the incident, Ms. Thomas provided an affidavit, and I think she submitted it to the state. I wasn't aware of the affidavit. I had no involvement in the preparation, no knowledge of her preparation of the affidavit. What I'd like to do is to screen share in a moment that affidavit, but before I actually screen share it, Judge, and I think Ms. Smith has seen it and is aware of the affidavit. Is that correct?
Yes, that's correct.
Okay. Judge, again, this was post-incident. And Ms. Thomas, kind of in summary form, I'll just kind of share a couple of the excerpts, indicated she's been in a relationship with Michael for over a year, that they spend a lot of their time together, that he is a kind, responsible, respectful, and caring person, is involved with his work, his community. In fact, the 1 incident, the 1 prior cycle that I alluded to, Judge, is a Fulton County misdemeanor charge related to another incident. In Miss Thomas's affidavit, She says that she was a victim of an assault and that Michael came to her defense. There was a woman who lived in the condominium where Miss Thomas and Michael were living, who came up and attempted to assault Miss Thomas, and Michael intervened. That other individual made a report to the police, and Michael was charged with that. That's a pending matter in state court. She says in her affidavit that she has witnessed an extraordinary level of concern from other people since this incident happened, and that this incident, where she's the victim, is entirely out of character. And I quote, is entirely out of character for her. That he's a valued and supported member of his community. And she's had apparently an outpouring of support from other individuals who are concerned about Michael's well-being and the fact that he's incarcerated. She also goes on to say that she has asked, and I don't know who she has, I'm assuming it's victim witness assistance or the DA's office, has asked that charges not proceed, has consistently made that request, and that she believes his incarceration or continued incarceration would not serve any real purpose, and feels that he is in need of structured treatment for basically for alcohol related issues. That is Ms. Thomas's affidavit. Now, about 10 days ago, I spoke with her, Judge, to inquire whether she would be appearing at this bond hearing. And in the course of that conversation, was advised that she's had a change of heart and is opposed to bond. I don't know whether she intends to appear today, but if she does, I anticipate that she's made that representation to the state. I assume that this affidavit was truthful when it was given, and that Ms. Thomas was being truthful in her statements. She obviously has a right to change her mind about the bond issue in this, and I understand that she has, but I don't think that that changes the representations that she made about Michael's character, his need for treatment, etc. And if she does appear, then I'd welcome the opportunity to ask a few questions with regard to that. If Michael is granted bond on this case, Judge, he would be the bond motion that I initially filed listed an address here in the Atlanta area, but since that time, I've had regular contact with I believe she's 84, his 84-year-old mother, Julie Santiago, his brother, Shane Denizard, and he has another brother, Dennis Denizard, who are all live together in New York State. That address is 8 White Oaks Road, Hyde Park, New York, 12538. Ms. Denizard, both of the brothers have indicated to me they have room for him. They would welcome him. And given the nature of his work, which is audio and video work, he has the ability to work remotely if he were released on bond. There would be zero reason for him to have any contact whatsoever with Ms. Thomas. There is, when we look at the IALA factors, the factors under 1761, I just don't think that there are any factors that would disqualify him. He's not a flight risk. He has no record that would suggest threats to the community, to property, to interfere with the administration of justice, or to influence witnesses. And the dearth of a criminal record, I think, supports that contention. While he has been in jail, Judge, he has been as proactive as any client I've ever had in trying to address issues. Michael has certified or certificates from accredited agencies for anger management. He's gone through a 12-step recovery program. He has also completed other coursework while he is there. The last of these is an alcohol and drug treatment course that he's completed, and I have certificates for those. What I'm asking Your Honor to do, you're going to see if the state introduces these photographs, you're going to see some fairly graphic photographs. The aftermath of what was, there was no weapon involved. This was apparently an injury or injuries inflicted with a fist by punches. And they're troubling. They're troubling to Michael Denizard, who has repeatedly said to me, you know, that this was an alcohol-fueled incident, not to excuse it and not to minimize it, but he's expressed great remorse for what has happened, and he is really, really motivated to get treatment. I didn't mention this. He has also been screened by and accepted in a 12-month residential program called Lotus Recovery. I've been in contact with their admissions director. They've confirmed in writing to me that that program is available. Ms. Smith and I talked about this in the context of a potential resolution of the case today. We're not ready. The state is not ready to proceed in that fashion.
Where is the program?
Judge, we have 4 different locations. They are, have a facility in Marietta.
Is there one in New York, or they're all local?
These are all Georgia programs. So
it's not something he could get involved with if he is on bond in New York.
That is correct.
Okay.
The program would be available to him, and if he relocated upon the resolution of this case, the game plan would be for him to get in that program. And again, it's a 12-month residential program.
Okay.
They're in Gainesville. They're in Marietta. There is a facility in Macon, but they've been in business for over 10 years, and it's a very well-established program. With that said, my request, Judge, on this would be for the court to consider a bond that would not exceed $20,000 in aggregate fashion, with provisions that would say absolutely no contact with Madison Thomas. Any other conditions that the court felt would be appropriate. If he is permitted to, if he's granted bond and makes bond and relocates to New York, there would be no reason whatsoever for him to even be in the state of Georgia except to attend court. And the family is prepared to have him, to house him, and also to get him into an alcohol and drug treatment program in the state of New York during the pendency of this case. That would be my request. I think it's an appropriate request. And with that, I'm going to screen share the affidavit from Ms. Thomas and then yield.
So why don't you email it? If you don't want the state screen sharing things, you don't need to screen share anything. So as long as Ms. Smith has it, then you can get it to me or to Ms. Nelson.
I'll send it to Ms. Nelson in just a moment, Your Honor.
Okay. Let me ask Ms. Hutcherson if she has any criminal history information on Mr. Denizard.
I just showed 2 cycles, this cycle and then a prior battery. No convictions on the GCSE.
Okay, thank you. Ms. Smith.
Yes, Judge, thank you. In this case, the state would be requesting that no bond be set for the defendant in this case. This is a very unfortunate case. After going through the discovery we already have, what happened, and speaking with the victim, the state is, of course, going to be asking for no bond. When we talk about the Ayala factors here, the state does believe that there is a huge concern of witness intimidation. The defendant and the victim were in a relationship. He knows where she stays. He knows her telephone number. He's able to reach her if he wants to. In fact, since he's been in jail, Ms. Thomas told me on yesterday that he's tried to reach out to her via telephone. And when he couldn't get to her, he would have family members or friends call her. So even if the defendant can go to another state in the pendency of this case before it resolves, it does not alleviate the concerns that the states have regarding witness intimidation. You don't have to technically be in the same state to intimidate a person. And I think Ms. Thomas's main concern is that the defendant in this case will continue to try to reach out to her to intimidate her in ways, even if he cannot do it in person. As far as the risk of reoffending, according to his GCIC, and defense touched on this a bit, but he does have an open battery case that happened 2 months before this case. So it was in January of 2026. Although that is a misdemeanor, judge, is a form of being violent. And if there's a case that happened 2 months before this one, and then this case happened that in a very serious way, it raises concerns that if the defendant stays in Georgia or goes to New York or to another state, if alcohol is involved, then it could be another risk of reoffending or assaulting another person, regardless if that's Miss Thomas or not. Also, when we talk about the danger to the community, it's not just to the community, but to the people in it. And I think one of those people in the community is Miss Thomas. That's one of the biggest reasons why we're opposing bond, because what happened. It impacted her, and it's something that she has to live through. I did invite her to be on the Zoom call, and up until last night, she said she would be on, but she just texted me and said that she is scared to get on. She doesn't want to speak, and she sent me a statement that I intend to read. But before reading that, I think the biggest point that defense made is that this is not his character. This is not what he does. It was alcohol, and I do understand that it may not be the defendant's character. He may not act out in this way before, but the issue that we're dealing with here, and why we're discussing bond, is the situation that happened with the defendant and Miss Thomas, which was an unfortunate situation, especially for Miss Thomas. But I don't want to I don't want to minimize how serious this case is, because the defendant may be a good person to have good character. At this time, Judge, if it's okay, I could read the victim statement.
You may, please.
Madison Thomas stated that she does not want him released. She said that this has affected my life in unimaginable ways, where I can't sleep for over 48 hours at a time. I have hyperventilation. I have a fear or a sense of being safe, because I no longer feel like I can be safe. I know that he, referring to the defendant, would murder me if he got a bond, considering how many people he's had reach out to me and find me on top of his incarceration in jail. I will not feel safe if he is released. I am terrified of him being released. That's the statement from the victim. But the last thing I wanted to say, Judge, was I understand Miss Thomas did make an affidavit in this case, and that was made directly after the incident happened. And she made it because she was still in love with the defendant. It had just happened. It was the first time, and she was kind of forgiven. But when she remembered and saw the scars on her every day of what she now has to live with because of this incident that occurred, she told the state, not that she is, the only thing she changed her mind about is the fact that she's now opposing bond. But other than that, she just added that it's now new terror, new injuries, that reminds her of how serious the case is. And it reminded her that she should oppose bond because of how serious it is. So altogether, Judge, the fact that the state does believe the Ayala factors of witness intimidation, risk of reoffending, and a danger to the community and the people in it, the state will be requesting for no bond to be set in this case.
Okay. Thank you, Ms. Smith. I appreciate that. And let Ms. Thomas know I fully understand why she chose not to participate. That's not anything that will be held against her in terms of, oh, how serious could this be if you were not here? That's not how I see it at all. Mr. Moran, I want to give you the last word since you're the movant in this situation.
Thank you, Your Honor. I'll be brief. I would call the court's attention to something that was in Ms. Thomas's affidavit, and it relates to and connects with this other pending case that Michael has. At the bottom of the first page of Ms. Thomas's affidavit, she says that on one occasion, a neighbor invaded my home by lunging over me, grabbing my hair, and attempting to forcibly remove me. Michael intervened, blocked, and protected me. Without him, I would have been seriously injured, and the situation would have been far worse. That's the case that is pending, Judge, in state court. And it was Ms. Thomas and Mr. Denizard who came to my office. I interviewed both of them relating to that incident. Ms. Thomas was adamant that Michael had been acting in her defense, and that this individual that Ms. Thomas had had difficulties with, this woman that was a large, aggressive person in that incident was the aggressor. Michael simply tried to intervene. So that's a matter that Ms. Thomas consistently said to me that Michael was not an aggressor, was not a voluntary combatant, but was rather simply trying to ward this woman off who had come to Miss Thomas's residence. I think it was late at night or early in the morning, and tried to barge in. I get this. I get the fact that the state has opposition to this, and I respect Ms. Thomas's view about this. But the court, I would say, respectfully, has a way to address these issues. Michael is not a flight risk. He has no history that would, in my view, respectfully suggest that he would be a problem to anybody, and particularly to Ms. Thomas, if he is permitted to make bond and is, as a condition of bond, required to reside with his parent and his family in New York State. The court has the ability, obviously, to make special conditions of bond that would restrict any direct or indirect contact, which we invite. I'm not privy to any of the information about his outreach or others' outreach to Ms. Thomas, but I can state, as somebody who has practiced before this court for many, many years, that I would do all in my power to assure that there is no contact whatsoever, direct or indirect. And I think that Mr. Denizard would be compliant with that restriction without any exception or any hesitation. He wants to resolve this matter. I think it will be resolved, but he's been in custody for 3 months, waiting for an arraignment date. And I would ask respectfully that the court set a bond with special conditions.
Okay, thank you. So I said at the outset, here's how it's going to work. And at the end of the conversation, I'll let you know what I'm going to do. I'm going back on my word because I need Ms. Smith to do a little homework for me. I do want to read the affidavit. I trust that's been sent across. I will review the affidavit. I have looked at 2 of the pictures. There's a picture that you sent Ms. Smith that says noise complaint. And when I try to open it, it's just a white screen. So the other 2 are very clear. One is particularly disturbing, as Mr. Moran forecast. But if the one that is labeled noise complaint was important for me to see, it may be that you got to come by with a hard copy or something and I can take a look. But that's not why we're holding off. I need you, Ms. Smith, to work with Ms. Thomas to see what she can provide you in terms of documentation, screenshots, forwarded emails, whatever she has that would document the efforts that she says Mr. Denizard engaged in to contact her directly, as in he tried to reach her, and then the indirect contact where friends or family members were reaching out to her ostensibly on Mr. Denizard's behalf. I'd like to see what that constitutes. That will inform how I handle this motion. I'm happy to give you a few days to do that. Obviously, sooner is important because Mr. Denizard is sitting in jail with the presumption of innocence in his favor. But this is not your standard aggravated assault, having seen these pictures. And so if he waits a few more days for us to get this right, that's us just putting safety first, and that's the right way to do it. So are you comfortable engaging with Ms. Thomas on that, Ms. Smith?
Yes, Judge. I'll get that over to you as soon as possible.
Okay. The noise complaint file, was that supposed to be a picture or what was that going to be?
Yes, Judge. It's a picture and it shows up on my end, but I'm not sure why it's coming up as just a white picture for you, but I can put that on a flash drive and give it to you.
Or maybe you could save it in a different format. It's a different format. I have a thing that opens this format, but when it opens it, it just is a white screen. So
I'll try resending it.
However you want to do that. Obviously, get the same thing to Mr. Moran. And Mr. Moran, I will review the affidavit when Ms. Nelson gets that to me. All right?
That's fine, Judge. And I just would ask Ms. Smith, I know she'll probably do this without the request, but any records, documents, or that you've requested, I'd ask that I be copied with those so I could have an opportunity to review those.
Of course.
Sure, as long as it doesn't reveal anything about where Ms. Thomas is or whatnot, but if it's the contact information from others, by all means, that should go to Mr. Moran as well.
Thank you very much, Judge. Thank you very much for your time and consideration on this.
All right, Mr. Denizard, you will not need to wait for another court date. We've had this hearing, we've made a record of it, and I will work with your lawyer and the prosecutor about next steps. And if Ms. Smith says, you know what, Ms. Thomas said it's going to take a month to get this, we're not going to wait a month to get it. She's got a couple days to try to gather that together, and we'll move forward then. All right, thank you, Mr. Moran. Mr. Denizard, you are good to go. Mr. Moran, we'll get a scheduling order out anyway, so we're moving the case forward independent of the question of bond, so you can get discovery and get the case moving.
Excellent, Judge. Thank you so much.
All right, bye-bye.
Bye-bye. Take care.
Okay, let's keep things moving. It would be great to wrap up shortly. Next is Mr. Andrews, who should be in booth 1, 4 North, booth 1.
Hey, Judge, he's standing right there. He's stating that he can't hear. Can you ask him if he can hear you?
Yeah, hey, Mr. Andrews, can you hear me?
Okay, Judge, have him go over to booth 3.
Booth 3. Hey, Mr. Andrews, can you go to booth 3? If he can't hear me, I don't know how he's going to know. Okay, he's going. But if you can hear me, hold on, Mr. Andrews, don't go anywhere yet. I can get you turned on, I think, 4 North, booth 1. Oh, yeah, there's no audio at all in booth 1, so let's try booth 3.
Okay, I'll report it to IT so they can take a look.
All right, thank you. We're connecting booth 3. Go to 3. Go to booth 3. Thank you. Hey, Mr. Andrews, can you hear me?
Yes, sir.
Excellent. All right, well, if you take a seat or lean down so we can see you. Ms. Rios, is this your case?
Yes, Your Honor.
Let's get you on the screen. All right, this is on for an arraignment.
Yes, I filed a waiver, I believe, and I also filed a motion for a bond. I believe I sent an email about it. I filed the motion on May 15th.
Okay, I didn't have it down for bond. Were you aware, Ms. Smith, that it was going to be a bond hearing?
I was.
Okay, then we'll do it. Let me just get the case up. All right, there's the waiver, so we'll do a scheduling order, and we'll get on the record now to talk about bond. This is 26 SC 001-927, State versus Andrews. Mr. Andrews, Ms. Rios is going to tell me in a minute why you ought to get a bond and what that bond should look like. I'll hear from the prosecutor, and then ideally, I'll let you know what we're going to do, okay?
Yes, sir.
All right, Ms. Rios.
Your Honor, Mr. Andrews is 37 years old. He's from Atlanta, born and raised. He's on a flight list. He has one daughter who is 14 years old. He was working for Pittsburgh Market and Deli. He also started his own scaffold company.
A what company?
Scaffolding. So he helps with stage and lighting, I believe.
Got it. Okay.
And he, his daughter right now was living with him, but is with his sister temporarily until he gets out. And so he needs to be out to take care of his daughter because he can't stay with his sister. She can't stay with his sister indefinitely. So I'm asking for right now he's in no bond status. And so I'm asking for a bond to be set the lowest bond possible. I understand the charges are pretty severe, not severe, but they're armed robbery. But I'm hoping that we could do a bond no more than 10,000 total.
Okay. All right. Anything else about Mr. Andrews?
I also don't believe he's on probation or parole. So I don't believe he's arrested to reoffend. I'm not sure. I didn't say that before.
Okay. I'm looking at his more recent Fulton arrests. There was a misdemeanor in 24, so he wouldn't be on probation for that. And then some ag assaults and other things, but those are old. Okay. Well, let me hear from Ms. Smith, and then we can also get the criminal history information. Ms. Smith?
Yes, Judge. In this case, the state will be asking for no bond to be set for the defendant. Like Ms. Rio stated, this is an armed robbery case where, and I'll limit the facts, but the defendant met up with an old friend who he's going to purchase an item from, like a computer. And when the deal went south, it's alleged that the defendant pulled a gun and took those items from the victim. Um, the state does believe that there is a risk to intimidate the witness in this case. The victim is an old friend of the defendant. They know each other. They have each other's numbers. They know like they were homeboys. So at the end of the day, this is someone that the defendant could potentially reach out to if he is released from bond and let back out. We also believe that there may be a risk of reoffending. I do know that on his GCIC, the convictions are from 2008, from a very long time ago, that the defendant had a weapon. However, with that time that has went by, the defendant is now has been arrested for having a weapon or a gun again. So the state does believe that there is a risk to reoffend, even though the defendant doesn't have a more recent felony conviction for having a gun or creating or having a violent crime on his history. Lastly, Your Honor, the state does believe that the defendant may be a danger to the community and to the people in the community, only because when this happened, it happened in a public location around other people were involved, and the state does believe that if the defendant engages in this type of behavior as far as using a weapon to take things from people, especially people that he know, he may be a danger to the community and to people that he is have previous relationships with. So because of that, the state will be asking for no bond to be set in this case. I did get an opportunity to talk to the victim. He stated that he believes the defendant is a dangerous person and that if he's let out on bond that he will hurt someone. He reiterated that they knew each other from a while back and that they've had previous disagreements. However, with the case we have in hand, he would oppose to bond in this case. But that is all from the state, Your Honor.
Okay, got it. You mentioned other people that this happened in public, et cetera, and you said other people were involved. Tell me what you meant by that.
Yes, Judge. So at this prearranged meeting between the victim and defendant, two other people were with the defendant. They were in a car. So they all came together. It was people, I don't know if the victim knew them, but it was other people with the defendant. And
Got
they
it.
were just in a public space, so they weren't at someone's home.
Okay. All right. Ms. Hutcherson, tell me what you have in terms of criminal history for Mr. Andrews.
I show a total of 6 arrest cycles, a 2011 conviction for possession of a firearm by a convicted felon, a 2008 conviction for possession of cocaine with intent to distribute, and then I show a conviction from 2013 for marijuana sale, distribute, or dispense, and that was with the Georgia UCP. He was on U.S. probation for that case and had a probation violation in 2023 for that offense.
Okay.
And nothing further.
Thank you. Ms. Rios, anything else on behalf of Mr. Andrews?
No, Your Honor.
All right, give me 1 second. All right, Mr. Andrews, at this time, I am going to leave you in no bond status. We are early in the case. I think I need to learn a little bit more about the case, and certainly Ms. Rios needs to get discovery. She's entitled to discovery, and she'll get that soon. And then I invite her to ask me to revisit this. Based on the nature of the allegations, your alleged connection to the victim, and the reappearance of firearms in your life, I think right now the right decision is to leave you in no bond status. We may shift that over time. I'll tell you, a bond of $10,000 doesn't get me real confident that we'd be able to get you back here. But right now, that's not the issue so much as no bond status based on what I understand the case to be about. So I will get the scheduling order entered. We will get discovery to Ms. Rios and keep the case moving along. Ms. Smith, anything else?
Nothing further.
All right, Ms. Rios, anything else?
No, Your Honor.
All right. Thank you, Mr. Andrews. You're good to go. All right, Mr. Phillips is next. Two. Ms. Rios, did you get, I sent you a chat with the phone numbers for Willie Taylor. Did you get those?
Yes, thank you.
You're welcome.
And Judge, my microphone wasn't working earlier, so I apologize, but thank you for the information on Sean Johnson.
Sure. I didn't realize that wasn't your case, but that no one needs to stick around for that.
Well, thank you, Judge. Have a good day.
You too. Bye-bye.
Bye-bye.
Mr. Phillips, will you raise your hand if you're here? Yep, there you are. Great. Let me get the microphone on. Can you hear me, Mr. Phillips?
Yes, sir.
Good, I can hear you. Good morning. Well, it's not even morning anymore. We got to hurry up. So, Mr. Phillips, you are on for plea and arraignment, and your attorney is
He's mine, Judge.
Ms. Wood. Let's get Ms. Wood on. She is. So, Mr. Phillips, I'm going to call your case up on my screen, but I'm going to let Ms. Wood tell me what is happening.
Judge, I filed a waiver of arraignment this morning. Ms. Smith and I have already been working on this case. I'm hoping that we can possibly get this in front of you next week for a negotiated plea. He's been accepted into a program. I just need to iron out the rest of those details. And then I think Ms. Smith just wanted to confirm some information about the victims and possible restitution and all that good stuff.
Got it. Looks like a bunch of financial transaction card charges. Okay. So Mr. Phillips, your lawyers entered some paperwork that includes a plea of not guilty on your part. I will get a scheduling order in place, although I don't know that we'll need to rely on that because it sounds like you and your lawyer are real close to getting you into a program or some form of treatment, assuming that's what you need. And that would result in a plea hearing that we could have next week in person rather than having you sit in a booth. You have any questions about any of that, Mr. Phillips?
Nah.
You doing all right?
Yeah.
Judge, I think he's probably frustrated with me because I met with him last week and I was hopeful that me and Ms. Smith could get everything squared away, but it's my fault, Mr. Phillips. We were very busy yesterday, so but we will do our best to take care of it next week.
Yeah, Mr. Phillips, we were in court till after 5 yesterday, working on other cases Ms. Wood has that were on a trial calendar, so they've been around longer. But I've heard her say real clearly, she's gonna work on this to see if she can help you through this, okay? All right. Ms. Smith, anything on behalf of the state?
Nothing further.
All right, keep Ms. Nelson posted and we will do what we can do.
Thank you, Judge.
All right. You're good to go, Mr. Phillips. Work up. All right. I am looking at the clock and what we've got left, and I just want to make sure we manage this. So we've got Mr. Is it pronounced Sorrells, Ms. Rios?
I believe it's Sorrells, and we have we're going to do a non-negotiated plea. Me and the state are not too far apart, and he has his probation revocations.
Yep, so I saw that. We also have Angela Williams. What are we doing with Angela Williams? I think this is one where we're handling a couple cases for McAfee, but we've got our own.
That's just a quick probation revocation, Judge.
Okay, so the other cases on the calendar are also revocations?
I believe they are all revocations.
Yes, Judge, that's correct.
Okay. And then we've got Mr. Vega, and that is a revocation.
Your Honor, that's my case. Yeah, there will be a stipulation and on that revocation.
Okay, great. So I am wondering how we fit all this in. I guess we just get started. Why don't we, we're going to save Sorrells till the end because that's going to take the longest. Counsel for Mr. Vega, does Mr. Vega need an interpreter or are we good to go?
We're good to go, Judge. He does not need an interpreter.
Okay, let me get him on a screen. To South, to. There he is. Let's get the audio on. Excellent. Mr. Vega, can you hear me?
Yes, I can hear you.
Excellent. All right, we're going to get on the record in your case. Your lawyer, Mr. Corrales, is here, and Ms. Smith, the prosecutor, is here. Mr. Vega, your case number is 24 SC 002512, and you had a probation warrant. I'm going to pull that up. Let me find it. Here it is. All right. And the allegation is that while you were on probation in the case you have with me, in January of this year, you picked up a DUI in Gwinnett County. And I remember your case. And you weren't supposed to be driving until you sorted something out in Gwinnett County. And yet you were driving because you got picked up on a DUI. So those are the allegations. Mr. Corrales, it sounds like Mr. Vega is admitting he got arrested for a DUI. And of course, he was driving if he got arrested for a DUI. Is that a fair statement?
Yes, Your Honor, that's correct.
Okay. You've got a little less than 3.5 years remaining on your probation, Mr. Vega. And this is your first revocation since you were released from state custody. All right. All right. So, Mr. Corrales, why don't you tell me what you've got in mind?
Judge, the timeline is a little unusual on this one. Your Honor sentenced him to 5 years probation, excuse me, back in December of 2024. And that sentence was to run concurrently with whatever sentence he was to receive on a separate Gwinnett County felony that got resolved a few months down the road. And in between those two is when he picked up the DUI. So he has been in continuous custody since July 8th of 2025. And Mr. Vega understands that, it was a poor decision that he made and that it's the reason why he has now further probation requirements in Gwinnett County in the DUI, but it's also the reason why he's been in custody for an additional 42 days. He did parole out on the Gwinnett case on May 6th, and he was immediately transferred to Fulton County. So he's been in the Fulton County Jail on this revocation for 42 days. While he was in prison, Judge, he tried to make the best of his time. He did do a reentry skills class, that's risk reduction, and a motivation for change class. And while he's been at the Fulton County Jail, he has been a trustee working. And so he has tried to do as much as he can while in custody. Certainly, the time in prison has opened his eyes, and the additional time that he's been in on this case has opened his eyes to the consequences of his actions. Is my understanding that the probation office is recommending a 30-day revocation and a return to probation with a special condition that he work a little more quickly on completing the community service that he was ordered to do. Under the circumstances, Judge, we feel it's a fair resolution. We ask that you follow that recommendation.
And your understanding of that recommendation is that it's 30 days prospective. So it's not, hey, you did 42, which is more than 30, so you get out today, but it would be basically revoke a prospective month.
No, Judge. My understanding is that that recommendation is 30 days with credit for the time that he's been in on this revocation.
All right. But it sounds like from what you're explaining, Mr. Vega has actually been in for almost a year.
Yes.
Okay. Understood. Ms. Smith?
Yes, Judge. In this case, the state is going to follow probation's recommendation, which is to revoke 30 days and reinstate the balance with the condition that he completes those community service hours. I would like to note for the court that Gwinnett misdemeanor case that he had resolved last year, and he was sentenced to 12 months probation. But as far as the revocation, the state will be following probation's recommendation.
Ms. Simpson, anything else?
Nothing further, Judge. Just to make sure that Mr. Vega understands that once he is released, he will be reporting to 2 probation officers and not 1.
And that's because he has misdemeanor probation somewhere?
That is correct, Judge. He is currently still under the misdemeanor sentence in Gwinnett County for the DUI and suspended license case, as well as our case.
And Gwinnett misdemeanor probation is not through DCS?
That is correct, Judge.
Okay. Mr. Vega, does that make sense?
Yeah, it makes sense.
Okay, you'll be living in Gwinnett when you get out?
Yes, sir.
You have a place to stay?
Yes, sir, with my mom.
What's the status of your driver's license?
Once I get out, I guess I'll check on it because I haven't been able to get any update on my license.
It's likely currently suspended based on the DUI, Judge, and so he would have to do whatever DDS requires for that, which is usually risk reduction and then a reinstatement fee if enough time has gone by.
Okay. Well, keep that in mind, Mr. Vega. If it's not a valid license, don't be out driving.
Yes, sir.
All right. Well, based on the stipulations and the discussion we've had, I will revoke 1 month of your probation and reinstate the balance. I will modify the probation such that you must complete the first 80 hours of your community service within the first 2 months of your release, and that'll get you some momentum. So if you haven't completed 80 hours of community service by the end of August, that might mean we have another meeting to talk about what it is you've been doing. I'll also just reinforce the point that you shouldn't be driving if you don't have a valid license. Okay?
Yes, sir.
Ms. Simpson, do you need anything else from me to prepare the paperwork?
No, Judge, thank you.
Mr. Corrales, anything else?
Nothing further, Your Honor. That concludes my business.
Yep. Thanks for your patience. Mr. Vega, you're good to go.
All right. Thank you.
All right. Mr. Folsom, do you have something I need to sign?
Yes, sir.
Okay, if you want to give it to Deputy Gordon, if it's just the poverty affidavit, I thought I had already signed something, but maybe it didn't get to you.
Right, it hasn't gotten to me. I have a proposed order, already, typed up for you to sign.
Okay,
And so here.
do you have your case number?
Yes, sir. The case number is 25C, D as in Victor, the number is 002186. Let's see.
Okay, I could have sworn I did the order for you, but if you've got one, we'll do that.
And then, the order is, this is this. So this is the order.
She did. I've seen all that. And you have that. Okay, you can't file it, I'll file it, but I'll take care of that, all right?
I appreciate it.
Okay, good luck.
Thank you.
One.
I guess be clear, so it means that it's, you're waiting, I don't have to worry about.
Correct. Once the order's in place, then they're waived.
Okay, thank you.
Sure, and you'll know it's in place because you get e-filing, you'll get notice.
Okay, thank you.
Mr. Williams, can you hear me? Well, I can't hear you. Can you say something?
I said, yes, I hear you, Your Honor.
Yeah, we're gonna need to get you in another booth. Could you go right next door to South Booth 2? Can you hear us?
Yes, I can hear you, Your Honor.
Much better. We can hear you too. So the glass is kind of messed up, but that's going to be all right. So Ms. Wood, are you handling Mr. Williams's revocations?
I am, Judge. I'm ready.
Great. Let's get you on. Okay, so I have 3 cases on the calendar. Are those the 3, Ms. Simpson, you're aware that we need to deal with?
Yes, Judge.
All right, let me find. What we've got here. All right, Mr. Williams, we're going to get on the record in your cases 24 SC 001-562, 24 SC 005-863, and 25 SC 000-299. And what brings us together is some warrants that were signed and a petition that the one that I see, Ms. Simpson, just alleges that he wasn't at his address of record and he is behind in payments. Is there more to it than that across the other cases?
That is the last updated petition I have as well, Judge.
Okay. Ms. Wood, is that what you're aware of? That it's, I'm gonna call it absconding, but that probation couldn't connect with Mr. Williams and he's behind on payments?
That's correct.
Okay. Is Mr. Williams acknowledging those infractions?
Yes, Judge. We're stipulating to that, and I believe we are in line with probation's recommendation. He's been in 48 days. Our request is to revoke 30 days and reinstate the probation with the caveat that he provided a good address. I did share that with Miss Simpson last week, and I believe there is also a request that he be a part of the Metro Atlanta Daily Reporting Center as well.
Okay. Ms. Simpson, what's your understanding of the basis for the Day Reporting Center request?
Judge, you had actually made that a special condition when he was sentenced to these cases. But he was not able to begin because he picked up, I believe, the docket ending 299, if I'm not mistaken.
So that was always supposed to be the case. It just never started.
That is correct, Judge.
Okay. All right. Well, that would fit with the case ending in 562 and 863. So I get it. Well, let me go to Ms. Smith. Ms. Smith, your thoughts?
Yes, Judge, the state is in agreement with probation and defense.
Okay. Mr. Williams, do you have any questions about what we've been discussing?
No, sir, but I wasn't aware of the daily report. That's it.
What about it?
I wasn't aware of the daily report.
Okay. Well, probation will talk to you about what that is and what you need to do when you reconnect with probation. Tell me, what's the address that's this new good address for you?
2211 Popular Point, Atlanta, Georgia 30349.
And who is there?
My girlfriend.
And you're able to stay there?
Yes.
Okay. Is that the address, Ms. Simpson, that you had?
That is not, Judge.
Oh, well, I don't mean what you had historically, but I thought Ms. Wood got you an address recently.
Let me clarify that.
I'm here for Mr. Williams. I've updated her with the address as well.
What voice would that be?
Lauren, the girlfriend.
Yes, Judge.
Oh,
I have it.
Lauren, the girlfriend. Excellent. Thank you, girlfriend. So that's your address.
You're welcome.
All right.
Yes, sir.
All right. And that's where Mr. Williams can stay.
Absolutely.
Okay. So you understand, because Mr. Williams seems surprised by it, he will be required to participate in the Metro Atlanta Day Reporting Center. That means that on weekdays, he is reporting to probation to get some job readiness, some drug treatment, etc. That's part of probation. It's not just for fun or a hobby, but it is a condition with which he needs to comply. Mr. Williams, you understand that?
Yes, Your Honor.
Okay. The monies
We'll make
that are
happen.
great. Ms. Simpson, the monies that are owed, are those unpaid supervision fees, or is there something else?
I believe those are just his probation fees.
Okay. So here's what I'm going to do. I find, Mr. Williams, that you violated your probation by being kind of hard to find and being behind on your supervision fees. I am going to revoke 30 days of your probation, reinstate the balance. I am reminding you that participating in the Metro Atlanta Day Reporting Center is a requirement of your probation. I will cancel out the balance of fees that are owed. So you're not going to need to pay that back. I'm going to waive your supervision fees for the first 3 months after you get out, so you can get on your feet, get doing what you need to do. But then you're going to need to start paying those supervision fees 3 months after you get out, and you'll be back on track. Ms. Wood, anything else on behalf of Mr. Williams?
No, Your Honor, thank you.
Ms. Smith from the state?
Nothing further. Thank you.
All right. And girlfriend, you're ready to manage this guy?
I'm good to go. Yes, I'm prepared.
Okay.
Your Honor,
Yes?
I'm sorry. This is the court reporter. Could I have the girlfriend repeat the address? I could not understand, Mr. Williams. The
Yes.
address? Okay.
What's the address where Mr. Williams will be?
2211 POPLAR Drive, Atlanta, Georgia 30349.
Poplar Point Drive.
Okay. I got it. Thank you.
You bet. All right. Thanks, everyone.
Thank you.
Your Honor.
Ms. Rios, is what we are doing with Mr. Sorrell something that gets him out today? Or it's non-negotiated?
It's non-negotiated, but hopefully basically what the state's asking for is 5 to 6 months. I'm asking for 3 years probation or 5 years probation with a incentive date of 3 years. He does need to get out because he's taking I would hope that he would get out today. I'm not sure, but there's a lot going on with him. That's why I wanted to see if we could resolve it today.
If I get him brought over tomorrow, can we do it tomorrow?
Yeah, because I was going to come physically anyway, because I haven't been able to get in contact with my client, so they'll probably show up. So yes.
Oh, except tomorrow, I don't mean to make you come in. You were going to come
I was
in.
going to come anyway because I haven't gotten contact with any of the people on the plea arraignment calendar, and it's going to be difficult. It's like 7 people show up, and everyone's having to get my number, so it would just been easier to show up. So I was going to be there anyway.
Exactly. Ms. Nelson, would we be able to add Mr. Sorrell's to tomorrow's transport calendar?
I'll have to see, Judge. I think I was not having anyone transported. I thought most of the people were on bond because of the World Cup. So I'll have to double check.
Okay, I'm happy to lean on a colleague to get a spot if we don't have spots tomorrow. Because it's a game day, I bet there will be spots available. But if you run into that concern from your friends in the sheriff's office, let me know, and I will make sure that we can get a spot.
No, it wasn't a problem with, actually, we have slots. It's Thursday. That's our day. It was regarding the World Cup and if they were transporting.
They are. We are doing, I'm trying to find this booth. We are doing preliminary hearings every day, game days and not. And so they are, there's always that core transportation of people who've got preliminary hearings.
Okay, I'll put them on the list.
Okay, I just want to get him on the screen. Oh, he's stuck in the breakout room. All right. Oh, he left. Okay. Well, we'll bring him over, Ms. Rios, and we will handle the revocation and the plea, and we'll see. I'm not guaranteeing it's the outcome that you're seeking. I just didn't want to delay it too much if it is the outcome you're seeking, but it would be less than 24 hours.
That works, Your Honor. Thank you.
All right. I think that's it. Did anyone else on the Zoom call have anyone else they thought we were covering?
Judge, we got someone in 4 South Booth 3.
Maybe he slid down.
Can you see him?
I gotta find booth 3. Hold on. 4 South booth 3.
Oh, yes, that's him.
Okay, great. Well, let me turn on the volume. What are you guys doing? Oh, about Miss Britton? Yeah. Do we know what happened? That's awful. Yeah, I got the email from Dr. Stubbs Brown.
Oh, okay. I just want to put it down there.
Okay.
Record and stuff, I tell you.
Thank you. That's rough.
It is.
I blame the boyfriend.
So, I follow the gentleman.
Hey, we'll see you, I guess, virtually next Wednesday? Okay, we'll figure it out. I'll be involved. All right, thank you. Mr. Sorrells, can you hear me?
Yes, sir.
Hey, were you able to hear the conversation we were having about bringing you over tomorrow or not?
Yes, sir.
I think you were in a breakout room, but at least that other booth was, but you may have been there the whole time. I'm out of time today, but I don't want to say, hey, we'll see you in a month, but we happen to have a calendar tomorrow morning. It just means bringing you over here rather than doing through a booth. Ms. Rios will be here, so it'll be an in-person situation. And we'll cover all the things she told you we were going to cover, revocation. I think maybe you're pleading to a case, but we'll deal with all that. It's just going to be tomorrow morning instead of today, okay?
Yes, sir. So I go to court in the morning.
Say that again?
So I will be going to court in the morning.
Yes, you will be on the bus tomorrow morning. I don't know what time they wake you up, but they'll get you up early. You'll be on the bus brought over from Rice Street to the courthouse, and you'll come up to my courtroom, okay?
Okay, thank you.
Appreciate your patience.
Okay.
Ms. Alexander, anything else?
No, Judge, that seems to be everybody.
Excellent. Well, thank you for lining everyone up. It went very smoothly. Just took a little while. We'll be good to go till next time.
Yes, sir.
All right. And thank you, Ms. Martin, for your coverage.
Thank you for having me. You all
All
have a
right.
good day.
Bye, everyone.